Lordship, I am praying for my lord, a small typographical error, my lord.
May I have your lordship's kind leave to mention, my lord, a writ petition pertaining to Justice, my lord, Amrita Sinha, my lord, considering her urgency, her ladyship yesterday granted leave to move it urgently today. The matter was filed on urgent basis, and my lord, matter is running as item number 3 in her ladyship's list. Now, my lord, her ladyship is not sitting from today. Urgent determination, my lord, has assigned to Justice Gaurav Khan. My lord, today, my lord, at the first sitting of the court, where matter was mentioned, but his lordship has refused to entertain the mentioning. My problem is this is a proceeding under the Highways Act. Without notice, this has been done. I have preferred a statutory appeal. Appeal at forum has fixed the first date of appearance in September. Police has given a notice tomorrow, my lord, my property will be demolished. I could not impress his lordship, my lord, but considering the urgency, her ladyship had already granted leave, my lord, matter has been.
The problem is, unless it is released, I cannot exercise my.
I mean, release, my lord, her ladyship is not there. His lordship is, my lord, not entertaining my mentioning, my lord. That is the outright, my lord, I have been. That is the whole. I can understand. Tomorrow is the date, my lord, for demolition.
Try once more at 2 p.m. before this. His lordship, you tell that you went and mentioned before us, and I have advised you to mention once again.
Very well, my lord. If, my lord, may I come back to your lordship, my lord?
What to do? See, we can't.
It is, my lord,
I can't pull out a matter.
Definitely, I understand. Yes, my lord. But, my lord, considering the urgency, her ladyship had granted leave to move today, and the matter is appearing as item number 3 in her ladyship.
All right, you try once more today.
Very well, I'll come back, my lord. I mean, great.
My lord.
This is appellate side.
My lord, appellate side.
All right.
My lord. My lord, one mentioning, my lord. My lord, for 14 May, my lord passed the order, Section 8 and 9, both the matter. Dr. Somit Chakraborty leading this matter, but wrongly recorded his name Somit Chaudhuri, my lord.
Okay.
Kindly.
Show it in the days list and you can correct.
Section 8 and Section 9.
Manrega matter, Millets. There are only 2 days left before vacation, Millets.
Before vacation, it will be difficult.
Millets, may I only impress upon your lordship. The difficulty is, Millets.
There is some personal difficulty for me, some health issues. We'll try if possible tomorrow.
Millets, I'll be deeply grateful, Millets. The report is
Definitely,
ready. We've received an advance copy of the report, Millets. Millets, we're considering prospective implementation of the law. If that happens, Millets, the workers will get back their employment. That's the.
Let us see. By today evening, let me see.
Millets, I'm deeply grateful, Millets.
Yes, please call.
Original said daily list matter item number 1.
My lord, I am appearing for the private respondent number 1, Mr. Devnath Ganguly, arguing in this matter. But in this time, Mr. Devnath Ganguly engaging to the another court. So I am paying for not today, my lord.
But who appears for the appellant? Pratyush Sinha. None appears for the appellant. so and so appears for the respondent after vacation. Give a date under the same caption.
Right, my lord. হচ্ছে একই সঙ্গে মামলাগুলো সেগুলো লিখুন।
For the response, madam.
My lord, the writ petitioner is suffering from amblyopia and squint eyes. He was treated as medically unfit for employment. Learned single judge sent him for medical examination before Regional Institute of Ophthalmology Medical College at page 92. Now, if your lordship kindly consider page 92, following persons were present. Number 1, RIO Kolkata, page 92. But my lord, following persons were present on the top. Number 1, RIO Kolkata. Number 2, also RIO Kolkata. Number 3, RIO Kolkata. Number 4 is the writ petitioner. Number 5, one doctor from EIS Sanctoria Eastern Coalfield, from the appellant side. Now, signature was done only 1, 2, 3. Now, on the basis of this medical certificate, lordship kindly consider the last line of page 92. As per the medical attendance rules, CIL, minimum physical standard of all cases of employees, candidate is fit for junior subordinate class 3, class 4 employees excluding watch. Now, nowhere appellant's doctor has signed. The doctors from RIO wrote these particular rules. Are they supposed to know? They are not. Now, on the basis of this medical rule, my lord, kindly consider the order impugned, which is at page 94. Now, the order impugned start that learned advocate representing ECL placed before this court a letter dated 18 February. My lord, this letter was an internal instruction to the council. Lordship, I think this could not have been considered because it was an instruction to my client to me, but that was quoted. That's why I did not make it part and parcel of this memorandum of appeal or stay application. Now, if your lordship kindly consider the order impugned at page 95, after quoting this instruction, learned single judge held, the letter, however, also says that PWD certificate means disability certificate, issued by Shiuri Sodor Hospital, Birbhum, which was submitted by the petitioner, on verification was declared not included in their office record, means a fake document was submitted by the writ petitioner. This, according to ECL, amounts to submitting fake document and furnishing false information. Now, the last paragraph. After going through the pleadings in the writ petition, and in particular paragraph 39 and portion of the letter, which speaks about the certificate, I find that document submitted by petitioner alleged to have been issued by Shiuri Sodor without assuming, without admitting it to be fake, is of no consequence. And then learned single judge directed to induct him as an employee. Now, my lord, with our due diligence, we could not show before the learned single judge what exactly Shiuri Sodor Hospital issued, because they misplaced it initially. During pendency of this appeal, my lord, we got the copy. I would like to include it under supplementary affidavit. I'm just showing for the satisfaction of my lord. Now, this first page is a letter issued by the writ petitioner. The second page is the disability certificate. This is what Shiuri Sodor Hospital said, that not even included in their record. The next page is the verification. And then Office of Superintendent Shiuri Sodor says, in reference to the above subject, it is to inform you that disability certificate as per your enclosed list of writ petitioner could be verified as his name is not included. Now a writ petitioner who has adopted a stance of submitting a fake document, is he entitled for any equitable relief?
At whose instance he was sent to the RIO?
Now, learned single judge, in my humble submission, emphasized on the medical report at page 92, which I have shown.
No. Who sent him to this Regional Institute of Ophthalmology?
Learned single judge.
By an interim order?
Yes. It's not interim order, it was a direction.
Direction,
Yes.
interim direction. When the writ petition was pending, he issued a direction?
Yes. During pendency of the writ petition, learned single judge sent him for further examination with Regional Ophthalmology Institute.
What is the opinion of your doctor?
My doctor said, my lord, kindly take up the stay application. Page 87 of the stay application. Now, Eastern Coalfields report of medical examination. Kindly see, amblyopia and divergent squint left eye, unfit for employment, dated 01/11/2021.
But when he was sent to the Regional Institute of Ophthalmology, your doctor is also one among the 5.
Yes, one of the 5, but he did not sign.
What was his opinion in the board?
My lord?
He was part of the board.
Yes.
Did he record any dissent opinion?
Yes. I couldn't get your lordship's question.
No. In page 92,
yes,
3 people have signed. All those 3 doctors are from the Institute of Ophthalmology.
Right.
Your doctor is serial number 5.
It appears that he was present, but he did not sign.
He did not sign. Did he record a negative opinion before the board?
No. Now, my question in respect of page 92 would be whether 3 doctors of RIO can say anything about our rules. What is our rules says? Well, kindly consider it. ECL guidelines is at page 97. The guidelines, eligibility, that is Roman 1. A PWD candidate should be suffering not less than 40% of following disability as certified by the competent medical authority: orthopedically handicapped, hearing handicapped, visually handicapped, and then disability certificate to be issued by medical board duly constituted by the central or state government under the acts and rules. Where is that? Did he produce? Did writ petitioner produce this proper?
You please come back to page 92.
My lord.
In the first line, it says, reference to the above, an inquiry was held on 4/12/2024 in the chamber of the director, RIO, Kolkata at 11:30. What was that inquiry? First line, respected sir.
My lord, this reference to the above inquiry held on 4th December 2024. This inquiry was in pursuant to the order passed by learned single judge. Learned single judge sent him to regional.
Where is that interim order, interim direction?
Well,
I have given a sequence-wise order. My learned friend never challenged the maintainability of the writ application. They accepted the order. Now, my lord, questioning, my lord, the medical.
Sir,
did I question that order?
If it is a case of production of a fake document, then you lose the trust and confidence of your proposed employer.
My lord, I have disclosed everything in my writ application, paragraph 39. If you lordships kindly see. That has been quoted in the impugn order. Page 39, para 39, my lord.
Page 39 or para 39?
Para 39 of the writ. That is at, my lord.
'51.
51, my lord.
51. Page 51 of the stay application.
No. So therefore, the petitioner sort of indirectly accepts that there is no record with that Suri Sadar hospital.
Yes, I have disclosed everything, my lord. I examined, but
Correct. But then with that certificate, you applied under the quota reserved for persons with disability.
No, there is no reserve category, my lord, here. Even I accept their medical report, as per their rule, I am entitled, irrespective of the, my lord, medical conducted by the RIO.
But once the fake document has been...
Well, I have in my writ application, I disclose, they have accepted, my lord, these things.
No, what they have accepted?
No, my lord, kindly see the orders, my lord.
No.
Kindly see, my lord, the first order, my lord, at 19th September 2024. They never challenged the maintainability of the writ application. Now they found, my lord, that the medical report is against them. And not only that, my lord, the Honorable Trial Court, my lord, specifically directed them to, under what category they wish to, my lord, provide the employment. They, my lord, submitted the that instructions before the court. That's why, my lord, the Honorable Court was pleased to.
This direction to submit yourself to the medical board is an interim direction pending writ petition.
They have not challenged this. They have accepted.
Maybe.
My lord.
What is your answer for producing a document which is admittedly fake?
My lord, admittedly fake document, my lord. Initially, my lord, I was treated by the hospital. But hospital, if, my lord, sometime in our state, my lord, hospital do not keep the, my lord, records. This is the fact in reality, my lord. I have disclosed.
On verification, the hospital has clearly stated that there is no record in the register giving your name, stating that the certificate. You say some trade union leader obtained the certificate for you. So therefore, it is admitted that it is a fake document.
Well, I have disclosed in my paragraph 39, my lord.
But then they have found out subsequently.
No. In initial stage, my lord, in initial stage, when the order was, my lord, passed, they knows everything. I disclose in writ application. They chooses not to, my lord, answer this, my lord. And they chooses not to, my lord, counter this paragraph. They accepted the orders part by the trial court.
Before you get a job, if you commit such a mistake, after you have given a job, what will you do?
Well, even, my lord, if your lordship kindly consider the medical report conducted by them, even as per their rule, I am entitled to the employment. Because they have not considered the medical report. That's why, my lord, the report of the Suri hospital. That's why they conducted the medical by them.
We can ignore all subsequent documents. You have to have an answer for producing a document which is shown to be fake.
My lord, paragraph 39 is my answer, my lord. Kindly see, my lord.
Then we'll hear the appeal. We'll fix a date.
My lord.
The short issue which falls for consideration in this appeal is whether the respondent writ petitioner is entitled to appointment in a post in the appellant company when admittedly a certificate produced by the petitioner, writ petitioner, stating that he is a person with disability has been found to be a fake document. The other issue would be whether the appellant can canvass the correctness of the order passed by the learned single bench, which was largely based upon a report, a medical report submitted by the Regional Institute of Ophthalmology, Calcutta, dated 9/12/2024, and whether such report would bind the appellant and whether such report is in consonance with the relevant regulation, relevant guidelines framed by the appellant via a memo dated 7/3/2013. The third issue would be whether the appellant can canvass the correctness of the medical report drawn by the Regional Institute of Ophthalmology, which examined the writ petitioner pursuant to an interim direction issued by the learned writ court dated 19 September 2024. To consider these issues, the appeal has to be heard, and therefore the appeal is admitted, and the order and direction issued by the learned single bench shall remain stayed. Liberty is granted to the respondent writ petitioner to file their affidavit in opposition if they so desire, within a period of 3 weeks. Reply, if any, within a period of 2 weeks. List the appeal under the heading hearing in the week commencing 7th July 2025.
Well, the copy which has been
may be granted to submit those documents under supplementary affidavit.
You give a copy.
Well, may I get a copy of this document?
Yeah, along with the supplementary affidavit, they'll give.
Well, then, my lord, then, my lord, supplementary direction may also be given to them.
Liberty is granted to the appellant to file supplementary affidavit, and advance copy of such affidavit shall be served on the learned advocate for the respondent writ petitioner, who is at liberty to file their affidavit in opposition to the said supplementary affidavit. Next.
My opposition would be, my lord, after filing of the supplementary affidavit.
In this, you file affidavit in opposition, plus you file affidavit in opposition.
Well, both opposition be filed, my lord, after serving the copy of the, my lord, supplementary affidavit. My lord.
Item number 3.
My lord, I am for the period. My lord, there is a quite some delay in filing the application. But the impugned order is challenged by both of us. I have also challenged, and my learned friend has also challenged. Lordship, there is a delay of 111 days.
Their appeal is on time. Your appeal is on time.
My appeal is limited to the extent of enhancement of the interest only.
On time or not? Both are delayed. Both are 111 days and onward.
So delay can be condoned. Both the appeals are no. What is the matter?
Only question is, in a case, there was a dependent entitled to monetary compensation. If someone is not provided with an employment or cannot be provided with an employment, or employment can be provided later, till that date, the dependent member will be given monetary compensation. So in this case, Lordship, what happened? Father died, the mother got compassionate appointment.
Compassion.
Then mother died, the dependent daughter remained. The daughter became widow just a month before the death of the mother. So she said, I will come for employment. That's what she said. Now, Lordship, that in 2000. In 2001, I said, you kindly take monetary compensation. She said, no, I will not take. She refused it. Then, Lordship, in due course of time, we found this document not there, that document not there. Actually, there were another 2 children of the deceased mother, whether they can. By this time, she has crossed the age limit of 45 to get it. So the single bench has come to a finding that she is entitled to monetary compensation from the date of the death. Now I say, since she refused it, it is a particular fact, is refused it. And the other fact is, all financial claims has to be a 3 years. In a similar matter, which I argued before this division bench, that it cannot be molded more than 3 years, I lost the matter before the same division bench. Matter gone to the Supreme Court. The Supreme Court said, you cleared the dues of last 3 years. That has been done. And in view of that, the SLP was allowed. Nothing more was given to them. So I have annexed those documents as well. Now, Lordship, in these circumstances, there is not a very clear guideline of the Supreme Court, but the Supreme Court in one case has dealt that 3 years prior to filing of the writ has given the money. So now in this...
No, in terms of your guidelines, yesterday also we had,
Lordship was...
As soon as a person dies in harness,
should be given. Immediate.
His dependent should be brought in the live register.
Lordship.
And till the dependent is considered for employment, they will be entitled for monetary compensation.
Yes. I offered him. In this case, we offered.
But she wanted an employment.
So that means, moment she said, now Lordship, probably it is running in the mind of the court, that both the 2 rights should run parallel.
No, now it is impossible for you to give appointment because she is crossed the maximum age.
Now, Lordship, once she refused it, now single judge has burdened me to pay the arrear along with the interest also. Lordship, kindly see, someone has refused. I will show it from the record.
No, refusal means refusal because she wanted employment.
No, that's a different issue. A person can
She
say,
says, I don't want compensation, I don't want employment.
no,
That's a different.
first we say that we are not giving you employment. We are giving you monetary compensation. Otherwise, Lordship, in this scenario, one compensation already we have given. One compassionate appointment already we have given to the mother. Then Lordship, situation demanded again. So it cannot be renewed. So we said, since you are a widow, you are maybe dependent on your mother, but you are a widow. So you must have.
See, the mother was granted compassionate appointment. She becomes your employee.
True.
So once that employee dies,
True.
her dependent is entitled for compassion.
Of course. Now, here when we found that there are other children as well.
Probably
so
in
then
objection.
whom to give? So in spite of everything, we said you take it. Then the employment could not be given. And Lordship, now, if your Lordship kindly takes two applications. If your Lordship kindly see page 35.
Now the compensation has been granted from December 2024.
Lordship kindly see. Then I will take your Lordship to two documents only. First, Lordship kindly come to page 34. This is Mongla Bawdi, means my deceased employee. 34. Lordship will find she had 3 children in page 35. 16, 14 and 5.
Bandra so-and-so, Sonali Bari.
Lordship has got. Now Lordship kindly turn to page 45. Statement of Mongla Bawdi. Lordship kindly come to at the bottom of that. In 2001, she is saying, I am not in a position to accept the monetary compensation as per the rule of the company, and I request the management to kindly provide me the employment. Lordship, now Lordship kindly come to the impugned order.
This was in 2001.
Yes, and immediately after that, incident happened in 2000. So immediately after that, we called him and we started recording that this has to be given to him. Now, Lordship, kindly see. Kindly now come to the impugned order. What are the... And in the impugned order, we was also not given chance to file our opposition as well. We could not deal with any facts and figures. So whatever I am giving before your Lordship is for the first time I am giving. As a motion stage, it was disposed of. Lordship, kindly see the impugned order now. May I place that? The petitioner is the widow or daughter of Tulsi Bawri, employed of Eastern Coalfield, who died on harness on Nato. The petitioner was married to Niren Bawri, who died on 10th October 2000, just a month before. In case of a petitioner, after death of her husband, she was dependent on a mother. So, Lordship, I pause here for a moment. So, I had to scrutiny whether in that 10 months, she automatically became dependent on her. Because employment is not, it's an exception to the rule. So I had to see only by 45 days, 26 November and 10th October, whether this 45 days she has become immediately dependent on. So this is the first presumption court has gone into. The petitioner further states that Tulsi Bawri was survived by the petitioner as only daughter and heiress. So this is the second factual mistake, because now I am showing from the document that the petitioner was having 2 siblings.
Well, they have died, death certificate has been annexed.
The petitioner, after the death of her mother, applied for appointment compulsion upon on 14 December 2000. The record revealed after exchange of the letter from the ECL and the petitioner's claim for compulsion was kept pending even in October 2022. It is now well settled that the compulsion and appointment is not a matter of right, but it depends on the prevailing scheme, if any, the employment organization for providing financial subsistence to the bereaved family on the loss of the sole breadwinner. The whole basis of the appointment under the compulsion and appointment gets frustrated with the passage of time. In the instant case, The subsidiary of Coal India, in short CIL, is the government undertaking. Its role, therefore, is like to a model employee and not like a private individual governed by their own vested interests. It is difficult to conceive that an application for the compassionate appointment, after having been processed in all respect, is kept pending for 22 years. The compassionate appointment in CCL is governed by the provision of National Coal Wages Agreement, in short NCWA. The privileged NCWA at the time of death of the employer or at the time of making the application for the compassionate appointment clearly states that in case of a female dependent, an employee, the compassionate appointment is to be provided if she is otherwise fit for the same, or in lieu thereof monetary compensation. I pause here for a moment. So for the female, that compassionate appointment is, Lordship was hearing a case yesterday, it was a male dependent. So here is the female dependent. So here it's not the mandatory that I have to do it. So I have offered him the monetary immediately, and that she refused. So basically she refused my discretion to give him monetary compensation, because I found from the books that 3 other children are there and the period of dependency was very short. It is only 45 days. Considering all those facts, I decided to offer monetary. Employment was not there. Now Lordship will find this order as if I could not give the compensation, as I could not give him the compensation and appointment. It has already almost like an order like damage on me. I mean, in a suit of damage, what she could have got an employment, then she should have earned this and this. So Lordship, it was not a mandatory on me. I had an exercise because...
Where is that guideline? Yesterday it was there.
Lordship, guideline. May I give? Another copy. May I hand over only one copy I have? Dekho. I'm extremely sorry, my lord.
But only chapter 9 is sufficient.
Yes.
Why are you giving you the entire set? You could have made a photocopy of the chapter 9 alone.
I should. Relevant page ta dili hobe to.
Option either
only relevant page is required.
Or employment. Option is
6 set 9.2 dili hobe.
But clause 9.5.02I says that she has got an option. She has an option either to accept monetary compensation of rupees 3,000 per month or employment.
Yes, she has an option or I have an option. I'm extremely sorry. Extremely sorry. No, it affects.
Oh. Oh, in case of female dependent,
yes,
is above 45 years, she'll be entitled to only monetary compensation. But admittedly, this lady was less than 45 when she made the application on 14th December 2000. Then 2I will apply. In case of death of permanent disability, so and so, clause. So if a female dependent is below the age of 45, she will have option either to accept monetary compensation or employment. The option lies with the dependent.
True.
She opted for employment.
True.
For 22 years, you did not do anything.
Lordship, kindly see. I process. Now I have annexed all the documents. In
But
this case,
22 years is too long.
Lordship, kindly see. She always said that I am the sole surviving heirs.
But your friend
Lordship,
says
if someone has come for employment, Lordship, kindly see. Clearly, my earlier service record says that other 2 siblings she should have. And now no, Lordship, kindly come to page 45.
42.
45. 45. Lordship, I have shown Lordship 45.
Yes. I have applied. I am the only dependent surviving member
Lordship.
of the deceased, and except myself, there is no other member left. My mother in the family. My father also expired prior to the death of mother.
So, Lordship, kindly consider the period. Period is only by way of an around 45 days. So, these are the factors which has given us something to think. Otherwise, we have given employment to her mother. It's not the case that we have not
No, that is effaced.
So I am forgetting that.
See,
because
she
once
came
she is
to-
regularized, I should not look into. But I am just saying that it is not the case that everywhere it has done. Now, Lordship, kindly turn to page 73.
Yes.
Now, Lordship, kindly, we express some doubts. Lordship, 3 and 4. The reasons for, now it has come to 2007, Lordship. The reasons for gap between the last date of working and the date of decease has not been justified. The same has to be justified with the documentary evidence. The copy of the death certificate in respect of the husband of Mongla Bauri, that is Niren Bauri, is not attested the same way. So, Lordship, that time of the death, she was
14 years.
So, Lordship, above that period, so it can be live in the live roster. We are not on this. I am talking about the question of the dependency.
But why it takes so much of time to process? And
Lordship, because she was not giving. That's why we said that kindly give me this document. Now, Lordship, kindly turn to page 84. It took me to 2013.
What was your reply?
There was a
84A.
84, and then the type copy starts at 84A.
Only one thing, my lord, may I point out, my lord. When, my lord, they confirm the entitlement and everything, my lord, only, my lord, then only, my lord, they offer either employment or, my lord, the monetary compensation. Once, my lord, they offer the monetary compensation, so after confirming everything, my lord, they are offering. Now this question, it does not arise. And, my lord, may I show to your lordship the one judgment of the Honorable Supreme Court interpreted, my lord, these provisions, my lord. What the Honorable Supreme Court has said, my lord, may I, my lord, place, my lord?
Let him come.
My lord.
Mr. Banerjee complete.
So, page 84, Lordship, this is another letter we wrote to her. You are once again advised to submit the following document clarification as stated below. The reasons of the gap between the last date of the working and the date of the death has not been justified because she worked. She did not turn up to the office for a long time. Then she died, and then it has happened. And her husband also died. And then another. The same may be justified. The original along with the Xerox of the death certificate in respect of your late husband. Because now, Lordship, we started to find out the date of the husband is also correct or not. We have to verify. With attested may be submitted. The age of one of the surety such and such who has been given declaration is not having 5 years of service. So, Lordship, this defect I informed her. Now kindly come to the next page, page 85.
Yes.
My mother, such and such, was an employee of such and such Mithapur Colliery. Died in harness on that. It is pertinent that my mother had one daughter that is undersigned, namely this, and her father also passed away. Since I am the only legal heirs of my mother, even she to take the stand in 2024. My only legal heirs of my mother. It is also pertinent to mention that the undersigned is the widow daughter of such and such. The undersigned, namely Niren Bauri, died on this. Consequent thereof, on my death, the undersigned became the only dependent severally. So that, Lordship, two things were very much troubling us for processing. We tried that very narrow time become dependence. Within a 45 days in a bereavement period, everyone comes to mother's place. So, Lordship, that 45 will be taken as a dependent. And the second thing is she stood by her stand that she is the only legal heir. Now, Lordship, kindly turn to page 90. 95. If your Lordship kindly come, the matter which I argued before this court and gone to up to Supreme Court. On the very first day, Lordship, the matter shall, petitioner shall pay to the respondent the due in clause such and such as amended up to the date for the period of commencing 3 years from the prior to the date of filing of the writ petition and the date. The payment shall be made within such and such. Then, Lordship, the next order. Upon hearing the counsel is granted 4 weeks time to file affidavit, Lordship. Then the learned counsel is granted 4 weeks time, Lordship. Registry to process the list in 99. Then, Lordship, page 100 is the final order. Leave granted. Having regard to the fact the respondent has not applied to the appellant management for seeking monetary compensation upon demise of her father. So, Lordship, they have to apply and get. That was the concept which I argue. It cannot be because it has to be first dependents, then monetary compensation. If someone's son is not dependent, staying in America in a practicing doctor, he will not take. So, Lordship, someone has to apply and get it.
But she has applied.
No, she refused. I shown to your Lordship that she refused. We offered. She said, I will pursue the employment.
You come to page 67.
67, Lordship. No, Lordship, can I show that? Lordship is
2003.
67. Yes, Lordship. I will not accept 3,000. Yes, Lordship. He did not apply. Kindly see,
No,
that is
this letter.
unwilling to accept 3,000 per month in lieu of employment. Kindly see that.
I beg to inform that
Yes.
my mother so-and-so,
Hmm.
and I have applied for employment in the place of the deceased husband
Yes.
as per company's rule.
Huh.
In this regard, I beg to inform you that I want service.
No, Lordship, I am not reading that line because kindly see the subject and the next para to it. The next sentence and the subject.
Unwillingness. She didn't want compensation.
Yes.
She didn't want monetary
And
compensation.
then I have shown that page also, page 72, where she said that I will not take. So that means she is not applying.
Now, what did the Supreme Court say?
Now, Lordship, kindly turn back to page 100. The management for seeking monetary compensation of a demise of a husband who had died in heart such and such till the date of this. We are of the opinion that the interim order passed in court on 14th October 22, which I have shown to your Lordship, directing the appellant to pay the respondent the amount under this, as amended up to the date for a period reckoning back to 3 years prior to the date of the writ petition was filed by the respondent in the High Court. That suffice the inter case. We have been informed by the learned court for the parties that the amount due and such has been paid, has already been released by the referee in favor of this. In view of the report, the impugned order such and such passed by the division bench and the judgment dated such passed by the division bench is quashed and set aside. It is held that the peculiar fact and circumstances is almost waited 21 years before approaching the
After
court.
21 years, she filed the writ petition. Therefore,
Here also, Lordship, she filed it in 2024. The writ petition, if your Lordship kindly see, here also the writ petition is filed of 2024. And the issue is going on from 2000. So she should have come in 2004, 5, 6. She waited for 24 years. And then when she crossed the age and then she came and then she said, I need this. Lordship, kindly 3 factors is there pricking my mind, Lordship. First, the very dependence. If it is not matter of right, she has to first prove the dependency. It is not wife. Kindly see, it's a widow daughter. Had it been wife, we would have not thought for the second time.
See, but then at least up till 2013, the issue was alive. You were asking for documents, she did not submit, etc. Page 84A, which you had just referred.
So that's what I'm saying. In between, she could have approached us. She all along refused me. And today I will be shuttled with the burden of the area with the interest. Lordship, can you see my conduct? I said that you give me this. And then in reply, she is writing, no, I am the only legal heirs. In reply, she is writing this, Lordship. She is not giving clarification. She should have said that though I was married, I used to stay with my mother. This is my voter card of that area.
But
no, Lordship, dependency in this case, since it is the daughter, it's not wife.
No, are you
married daughter?
Are you entitled to raise this issue, having decided upon her eligibility and offered monetary compensation?
No, I will.
You cannot reopen that issue.
No, I have.
Once you are satisfied that she is a dependent, you said we cannot give you employment, we will give you monetary compensation. She said, no, I want employment. So the issue.
Then moment we got to employment, because in lieu of, we said in lieu of.
So no. Moment you take such a stand,
that will be a too harsh estoppel against.
No.
Too harsh estoppel against.
Once you take a stand that she is entitled to something under the regulation, either employment or compensation.
I said you take it because we know that this usually comes on us. So always we offer and start finding them. So Lordship, that interim, same thing. Like
where is the copy of the writ petition?
Lordship, copy of the writ petition we have.
Well, I have annexed with my stay application, my lord.
Oh, in your appeal.
In my
It is there in their appeal.
Yes.
In which paragraph have you said in the writ petition as to why you approached the court only in 2024?
Well, here, that judgment I will distinguish because that judgment is related to.
We are not on the judgment. We are on your facts.
My lord.
In your writ affidavit, writ petition.
Paragraph 13, my lord, kindly see. And 14. Paragraph 14, if your lordships kindly come. My name has been placed.
In the
my lord
final employment status list.
Yes. Now, if your lordships kindly see final employment status list, my lord.
Where is that document?
My lord, I have annexed, my lord. No, status কোথায় PTO টা কই দেখি আমার রিড টেবিল প্রথমে দেখি page 52, my lord. 88, my lord.
Page
88. This list, my lord, they have published up to October 2022.
Page
88 of the, my lord, stay application.
Okay.
Top, my lord. Status of employment under National Coal Wage Agreement, October 2022. So now, my lord, they placed my name, and still, my lord, they are showing under process. And after filing of this writ application, my lord, they have entire, my lord, this list has been.
Where is the name of the petition?
My lord, I am coming, my lord. ED number 3292. My lord, next page, page 89. 3292 at my lord left hand side. Late Tulsi Bauri. Bauri. Then my lord kindly come. Widow daughter. Under process. Under process.
So this was up to October 2022.
October 2022. Thereafter, I filed the writ application and they have, my lord, deleted entire, my lord, this list. And I downloaded from the
24. If it is 22, Lordship, kindly see that when at the age of filing, what was her age at the time of filing? Kindly see.
Age must be 48 years.
Lordship has to. Now, 2024, she was 52.
So at least up to 2022, there is record to show that her employment.
So if it is
was under process.
If it is 2022, then I would say then it is. We should not infer that it is under process. We should infer that this is the record available. Why? Because whatever the status after 45, it is not there. So
she will not get it.
not there. So once I am keeping something on the record, that does not mean that it is under process. Process has to be as per law. So Lordship, if 52 minus 2, that is 2022, so that time she was far behind the time of 5 years from the date of this. So we have to keep all these records alive, whom we have given, whom we have not given. If not given, what is the reasons not given? So Lordship, kindly see, till 2013, she took a stand which was not been much accepted to us. She said, I am the only legal heirs, and the dependency. Now, Lordship, kindly see the dependency. Now, kindly come to the prayer of the writ petition, Lordship. If your Lordship kindly turn to the writ petition.
She wanted compensation.
Now, Lordship, if I take the three things, that dependency is here is much under cloud, Lordship. The only thing we try to see that someone was really dependent on. Lordship is not finding any statement in the writ petition that even prior to she become widow, or Lordship is not getting any document which I was trying to submit before your Lordship, that the voter card, Aadhaar card, anything will not clearly shows here that she was really staying with her mother. That was actually, Lordship, we have to look into, because this is the public money for social legislation we are giving to someone. Lordship, we have to be extremely careful there. Lordship, from the entire thing, someone has to prove that she was a dependent. But here, Lordship, in the pleadings also, Lordship will not find that
it's there.
No, Lordship, kindly see, except the word dependence. Lordship, I have checked that, Lordship. Kindly see his
page 45, para 15 and 16.
Page 45 of this.
16 is more specific.
Para?
Your para 16, she is the one and only daughter.
Yes, that's the wrong statement.
Her mother was the sole breadwinner of the family, and after her death, she is suffering from crunch of financial crisis.
So this is
the
just...
petitioner was all along dependent on her mother, even after her marriage and after the death of her husband.
And this has to substantiate with a voter card or Aadhaar card or something. And Lordship, kindly see this statement. This is the most generic statement. They know that they have to say dependency. If they can support with any document, Lordship. And Lordship, I did not get a chance to use my opposition here.
That is correct.
And Lordship, from the service extract, I have shown to your Lordship that it is a declaration of her mother that she has 3 children.
They say the other 2 are dead already. Where is the death certificate?
I mean, well, they also in there, my lord, if you also kindly come, page 50A, my lord. They have conducted the screening test. The screening also says, my lord, at bottom of this document is not
50A.
50A. This is not so much legible.
58 or 50?
50A, my lord. 50. This is not so legible. That's why I made them, my lord, later to sub the legible copy. Which page can come?
There are 2 page numbers, sir.
50, my lord.
Huh?
50A.
There are 2 page numbers. I am saying you are saying the same thing repeatedly.
In my copy, my lord, annexure H, my lord, 50 and 50A, my lord, next page. At bottom, my lord.
In the service record also says that they have Lordship, I have annexed and I have
died.
You give the correct page number.
Well, this one, my lord, page 50A, my lord.
It is in his appeal or your appeal?
His appeal, my lord.
Ah, that you say. What is this?
At bottom, my lord, kindly see.
Status of dependence recorded.
Then last, my lord. 50A, my lord. I hereby that Mongola Bauri is the genuine daughter of late such and such, has no other dependent to work in ECL.
Question of genuine daughter, this is the service extract, my lord. Question of genuine daughter is not thing. The two things which is pricking our conscience is that the dependency and other legal heirs. And why did she say that I am the only legal
After
heir?
considering everything, they offered MMCC. Otherwise, they would not have offered MMCC.
And it clearly says on police verification also, there is no other dependence.
And I have also annexed the succession certificate because they were not paying the amounts. I have annexed that succession certificate. In my writ application, my landed friend has not annexed the writ application. You will find from my stay application. The succession certificate is there.
My stay application, page 56 and 57. Let's see if he is relying on succession certificate. Lordship, kindly see.
And after considering everything,
Applied
after
on
police
18
verification,
for a
their
certificate,
system is, after considering the entire thing, even I found fit in the employment. That's why my name was placed under headquarter list for providing employment.
We have to first place and then we have to do this. Now, Lordship, kindly see. Here is a case, it is clear except one paragraph 16 averment, and which I did not get a chance to controvert. The dependency is not clear. Second thing is legal heirs, dead, alive, that's a different issue. Now the legal heirs are there. Why should she sigh out from saying that, yes, I had the shivling, they died on this is the death certificate. Lordship is not getting the death certificate on record. Lordship is not getting voter card, Aadhaar card of husband, children, petitioner, along with her mother of the same address. That also Lordship is not getting. Lordship, only because one paragraph they have afforded, and that too drafted only in 2024 by an learned counsel. Lordship, based on that, can we go back to that period? And when the Supreme Court in other cases has said so. Lordship, this needs some consideration, Lordship. Kindly see whether in this case, whether the dependence has to be clearly established, and then this will...
All right, we will consider. Sir, delay you can condone in both the appeals. We have heard the learned advocates for the parties. There is a delay of so and so days. As the delay has been properly explained, the application is allowed and the delay in filing the appeal is condoned.
Well, only one document, may I show to your lordships. Well, after the passing of the single bench order, my lord, they have issued this letter for submission of the document for payment.
Lordship, I am facing contempt, Lordship.
No.
So cause issues against me.
This was, my lord, this letter was long before.
No, this document is there in your
yes, my
application.
Yes, my lord, my application.
24.
Yes. They have offered after this, my lord, order passed by the trial court. And my lord, may I show to your lordship on Supreme Court judgment, my lord, in this regard, my lord, considering, my lord, this rule.
This
yes, National College Agreement, my lord. My lord, I have the compilation annexing the all orders where, my lord, the special bench as well of this honorable court directed, my lord, the monetary compensation has to be paid from the date of death with interest. And honorable Supreme Court also says only one relevant order, my lord, I will show to your lordship.
Kindly don't take me.
That is
at surprise. Kindly give me a copy of the document.
Reported judgment 2018, my lord, page 63, my lord.
Lordship,
only one judgment you are referring.
Only one judge. I can, my lord, but if your lordship desire, my lord, I can, my lord, because
page 63.
Page 63, my lord. Considering the self-same rule, kindly see, my lord, this order, my lord. What the honorable Supreme Court says. Single bench refer kiya. DP 193.
Which paragraph?
My lord, it starts from paragraph 3, my lord.
This is Mr. Ghosh, this is extremely harsh.
It is
give me the judgment copy so that I can read along with you.
All these
you take one copy, we will share.
No, Lordship. In that case, Lordship, I will.
No, you go through. It is matter concerning your company only.
Well, it is the stand of the respondent organizations that they were prepared to grant monetary.
Paragraph.
Paragraph 3, my lord. It is the stand of the respondent organization that they were prepared to grant monetary compensation rupees 3,000 per month to the appellant, whereas it was the appellant who insisted for employment. The learned counsel has also pointed out that the second respondent is prepared to put one of the sons of the respondents on live roster in terms of the agreement such and such. It is submitted then, my lord, kindly come. Last paragraph, paragraph 5 of this, my lord, judgment. The learned counsel for the respondent number 2 organizations has invited to our attention to the decision in this court in a case of Canara Bank versus Mahesh Kumar and submitted that the compensation appointment is not a matter of right. And there is a discretion available to the employer. We have no quarrel with the statal positions, but the instant case is not the case of the discretionary compensation appointment governed by the statutory guidelines. It is governed by the scheme as agreed by the parties and which becomes the part of the bipartite agreement. The terms of the agreement are very specific and give no room for any discretion. Now in para 9.3.5.0 II of the agreement, it is very clearly and specifically mentioned that a female dependent, if below 45 years of age, has an option either to accept the monetary compensation or employment. It is not an option reserved to the employer, but it is an option given to the employee. In terms of the agreement, only that the appellant had been insisting that she should be given appointment if she is otherwise eligible in terms of the bipartite agreement. But the second respondent kept on insisting that the son being above the age of 12 years would be kept on a live roster until attain the age of 18 years, such and such. Now, next paragraph, 9.3.5.0 II would come in play only in a case of 9.5.0 II does not operate. Here, my case is only 9.5.0 II, not 3. 3 was yesterday's matter. Employment is assured to the dependent in terms by bipartite agreement. If the female dependent opts for employment, there is no further discretion left to the employer unless he is otherwise ineligible. There is no such contention raised by anybody. In these circumstances of this case, we have no other option but to set aside the judgment of the High Court and dispose of the appeal in the proper perspective of the bipartite agreement. The learned counsel for the respondents put out the employment of the appellant at this stage, and age may not be workable relief since the appellant herself has later requested for employment to her son. But question as to how to compensate the appellant for the period 2004 to 2018, that is the date of death to date of judgment of this honorable court. Having regard to the entire facts of the case, we are of the view that the interest justice would be met and complete justice to the appellant will be rendered. In this case, appeal is disposed of the following. The second response is directed to appoint one of the son of the appellant who has otherwise become major as of now, as per the choice of the appellant within 2 months from today. Needless to say, the appointment will be governed with the commensurate skill and qualification. From 2004, as ordered by the High Court, the appellant shall be paid 3,000 per month along with interest at the rate of 7.5% from the respective dates towards all other claims on account of loss of employment for the last 13 years. As far as the appellant is concerned, it would be just fair and reasonable that the lump sum amount is paid to the appellant, which is fixed 5 lakhs. So employment MMCC with 7.5% interest as well as cost of 5 lakhs was imposed against this coal company.
But interest was payable, only from the date of the order passed by the High Court. What is that date? From 1/2/2004.
2004. 2004 was the date of death of the employee.
Death of the employee. Here also they have given
date of the employee.
And but 6%. You wanted 18%.
18%. That I will leave it to losses. And now another judgment of the Honorable Supreme Court regarding the payment of monetary compensation against the this coal company. No. কত পেজটা কতটা? Page 319 my lord.
319.
না এটা নয়, যেমন ওটা কই, ডিভিশন বেঞ্চ জাজমেন্ট, সুপ্রিম কোর্টের ওটা কই, আরে যেটা তোমার জামাইয়ের চাকরি বিবিধ
ডিভিশন বেঞ্চ
পেজ 139 my lord. আরে কি পেজ নাম্বার গুলো গন্ডগোল গেছে, এটা বের করো। 143
Only thing, the moot question here was what he is saying, we are no quarrel on the law.
No. We have understood your subject.
So kindly see this particular fact and circumstances of 45 days and then her behavior to the extent. So that has
That
to
we
be,
will
I need a chance to show that.
Which is the other judgment?
My lord, 269, reported in 2024 SCC online.
269.
269. Relevant paragraph is, my lord, paragraph 12. (11) and 12.
No, wait, sir. There are 4 page numbers.
273, my lord. Page number গুলো যেরকম তেরকম করে তোমরা দেখো না, চেক করো না, এভাবে চিফ জাস্টিসের ঘরে মামলা করতে হবে। 273, my lord.
In all cases was wife and son, not married daughter, then widower become dependent. This factual difference remains, Lordship.
What is the citation?
Then Lordship,
2000
keep the money with me.
2024 SCC online.
Page numbers are not tallying. What is the page number you said?
Well, if you also kindly see my copy, my lord.
No, I'm then.
Paragraph 11, 12.
You ask them to get it. It starts at 269.
No. আরে আমি জজ সাহেবের থেকে পেয়েছি, তোমাকে তুমি তো দাওনি আমাকে। না তুমি দাওনি আমাকে, জজ সাহেবের থেকে পেয়েছি, আর দই তোমাকে।
Which paragraph you wanted at?
11 and 12, my lord.
At the end of the day, widow of the deceased employee is neither granted compulsory appointment nor she was granted monetary compensation, entitled to in terms of allowed order division bench so and so was set aside, appointment being irregular is quashed.
That was the appointment to the son-in-law. That was the issue, my lord.
Pay monetary compensation widow of the deceased revised from the date of demise of her.
Yes, here also same thing has been, my lord, passed by the single bench.
And again, here it is.
And even all the judgments I have given, my lord, even a special bench, my lord, on this issue, my lord, this honorable court decided.
So this question has to need to be looked into. So there are 2 rival judgments. I have given one that in that case it is only 3 years from this.
No, that was a case where peculiar facts 21 years after which.
Lordship, here also
after
24 years.
You have noted your submission.
Well, in that matter, my lord, after 21 years, the application was made. Correct. In that matter, my lord, which my learned friend is saying. And here, my lord, immediately I made application for employment.
All right, we will consider. Judgment reserved. You have put page number 270.
But Lordship, tomorrow I am facing contempt, Lordship.
You inform the learned judge, they will adjourn the contempt. You tell the court has heard both the appeals, he will not press for it. He will take adjournment.
My lord, in my appeal also is, my lord, I have 2 judgments of the Honorable Supreme Court, my lord, where, my lord, 18% interest has been, my lord, given. Only that part, that I am handing over to your lordship, my lord.
That we will decide.
My lord. দুটো করে আছে, দুজনে।
Lordship, I will request your Lordship to look into one fact, that whenever I accept and I process, it does not mean that my acceptance of her dependency. It is always subject to further scrutiny.
Yes, we will consider.
I am deeply obliged, Lordship. I am deeply obliged.
New application item number 5.
Five. My lord, I am appearing, my lord. Appeal. My lord, delay is 198 days, my lord.
My lord, before my lord takes up the delay, my lord will come to page 62 of the appeal.
The stay.
Of the stay.
These all are beyond monetary limit.
Yes.
62 of the stay. 15,000. 15 lakhs.
Below monetary.
Come on, all these appeals, my lord, 5, 6, 7, and 9, 10, 11 are below monetary.
One thing, my lord, with regarding to item number 104, yes, it is a penalty has been imposed on 15 lakhs. Now, with regarding to item number, my lord, next two items, there is, my lord, confiscation of that vessel and the.
First, we have got Casta 104.
Yes, sir.
104, it is only 15 lakhs.
15 lakhs.
What is the name of the importer? Pardon?
B. Ghosh.
B. Ghosh.
Yes.
This is Casta 104. Then the next one is Century Star.
My lord, I am for Century Star.
That is
15
also
lakh penalty.
Casta 105.
15 lakh penalty.
Then the next is
The other two, I have not.
2 lakhs. That is Casta 106.
My lord, that is with respect to Pandua Cruise.
Pandua.
We are not representing.
All right.
Actually, on
Both
Pandua
the-
Cruise, 7 lakh.
5 plus 2.
Yes.
Then another one is
Travel Bureau.
Pardon?
MS Travel Bureau.
No.
No.
That's it.
My lord, is item number 9, my lord.
9.
9.
My lord, that another service.
It is also, my lord,
50 lakhs.
Same.
Service current.
No.
same. ওটা কম আছে।
Copy there?
Copy the copy.
The Century, why have we filed 2 appeals for Century?
There are two separate matters, sir.
My lord,
One is related to confiscation of vessel and one is relating to confiscation of barge.
my lord, they are.
May
But in both the cases,
yes.
only 15 lakhs penalty.
No.
112 and 112 A and B.
Yes.
Correct.
Two separate show cause notice, my lord.
Correct. But it was adjudicated by a common order.
Correct.
Correct, sir?
No, my lord, separate orders, my lord. If you may I humbly submit. The separate show cause notice, separate adjudication order, my lord.
All right. Then we'll see. But still, in Casta 6 of 2025,
Yes.
what is the penalty imposed?
6 of 2025, may I submit, my lord.
Penalty is 15 lakh
2025.
rupees. And there is a redemption fine
Yes.
of 60 lakh. But a redemption fine is not under the purview of the monetary limit. Only duty and penalty, not even the value. But earlier one matter, they were showing the value of the gold, but the value is not covered. So only penalty and duty are the concern. So here, my lord, even if your lordship takes the redemption fine together, it will go to 75 lakh. The penalty is 15 lakh.
But the question is that they have paid this before issuance of the show cause notice. Ultimately, the adjudicating authority matter travel before the learned tribunal. Tribunal held that
That is on merit.
merit. But the thing is that ultimately the consequence is that when they have already paid the redemption, now we have to refund. Since they have to pay, now it has been held that the
They
goods
will file an application for refund.
my lord, therefore, my lord.
Then you say unjust enrichment, credit.
Everything they are never giving.
No, my submission
giving
before your
Never
lordship.
get anything.
My submission before your lordship.
They are not.
Monetary
giving
limit
even
is
back.
applicable. For refund, there is no monetary limit, my lord. So I want to come
this
under
is-
the purview, my lord, that since this is a case of refund, we have specifically
this is not a
pleaded
case of
in our state
What
petition, my lord.
Not case of.
Sir, please come. There is a delay of 198 days in filing the appeal. As the delay has been properly explained, the same is condoned, application is allowed. Sir, this you have to take separate order.
আমার case তো আমাকে ঘোরাতে হবে।
Each one, you have to put this. This appeal, I'll dictate one. This appeal has been filed by the by the Customs Department, challenging the order passed
Item number
by the
5 and 9. Item number 5 and 9. দিদির নাম দিয়ে সংখ্যা।
Customs Excise Service Tax Appellate Tribunal, Kolkata.
এটা আমি লিখি।
In
904 04টা কোথায় গেল? দাঁড়াও দেখি সব করে দেব, সব হয়ে যাবে, সব।
in Customs Appeal 7
My lord, we have mentioned in my cost 71303.
71303 of 2013. Charanjan, preamble it is there. You don't give this number, you give this number. 71303 of 2013, which was filed by the respondent, and by the impugned order, the appeal was allowed. The revenue being aggrieved by the same have preferred the present appeal. We have perused the order of adjudication passed by the Commission of Customs within bracket Preventive West Bengal, and we find that the penalty imposed on the respondent is far below the monetary limit fixed in the circular issued by the Central Board of Indirect Taxes and Customs dated 2/11/2023, which has fixed the monetary limit of rupees 1 crore for filing of appeals by the department before the High Courts. Since admittedly the penalty imposed is lesser than rupees 1 crore, the revenue cannot prosecute this appeal. Accordingly, the appeal stands disposed of on the ground of low monetary effect, and the substantial questions of law suggested by the revenue are left open. Sir, same order for item 5, 6, 7, 9, and 11.
9, 10, 11.
9, 10, 11.
দাদা 15 লাখ 2 লাখ।
Thank you.
2 lakh na 7 lakh.
I'm led by Mr. Banerjee.
Ah, yes. You put Mr. Bhaskar Prasad Banerjee's name, capital letters.
Ordinary.
In bold.
Please, দাদা দিদি। Deeply obliged.
Grateful.
Yes.
Hello, only the item number 9, there is a delay of 289. The delay will be different.
That
Delay ta dekhen na.
Item number 8.
Sunday from there to Trichy. Monday I have to come back. Wednesday I have to once again travel. No, yes, within the state I have to travel. Then 3rd I have to travel once again. Come back on 5th. Come here once again on 8th. That's what I was thinking.
Yes, my lord.
You are opposing the delay.
Your lordship. My lord, in this matter, the issue is involved is approval by the specified authority, whether it will be PCIT or higher.
These appeals, why are you preferring 2023 order? Learned judge has given liberty, even assuming it is so, that it's a curable defect.
Your lordship. So whatever time frame they have delayed, if they want, they can complete all thing in this particular time.
They would have passed an order by now.
Your lordship.
That reassessment order you could have passed long back.
Your
At
lordship.
least 8 months back you could have passed. And similar order we had upheld.
Your lordship, it's already covered, your lordship.
And this appeal has been filed by the revenue, challenging the order passed by the learned single bench dated 21st June 2023 in WPO 1065 of 2023. The appeal is barred by time, and as there is a delay of 397 days in filing the appeal. The learned advocate appearing for the respondent writ petitioner would vehemently oppose the prayer for continuation of delay. However, considering the fact that a legal issue has been raised and decided by the learned single bench, we are constrained to exercise discretion in the matter and condone the delay and deal with the appeal on merits. Accordingly, application is allowed. Delay in filing the appeal is condoned. Para. The writ petition was filed by the respondent herein, challenging an order passed under section 148 capital A within bracket D of the Income Tax Act 1961 for the assessment year
1718, my lord.
2017-18 on the ground that the statute that the approval of the specified authority, inverted comma, in terms of section 151 within bracket 2 I's of the Act has not been obtained. The writ petitioner contended that the specified authority in the assessee's case is the principal chief commissioner of income tax, which fact was not disputed before the learned single bench. The learned single bench referred to the instruction issued by the Central Board of Direct Taxes in instruction number 101/20-22 dated 11th May 2022, and in particular para 6.2 Roman 2, wherein it has been stated that for the purpose of issuance of notice under section 148 of the Act for the assessment year under consideration, the approving authority will be the specified authority under section 151 within bracket 2 I's of the Act. Further, on facts, it was found that notice has been issued to the assessee after the expiry of 3 years from the end of the relevant assessment year, and at the time of issuance of notice under section 148, the act was extended to taxation of and other laws by converting notice under section 148 into section 148 capital A within bracket B of the Act, and the learned single bench found that the statutory compliance required to be adhered to under section 151 within bracket 1I and 2 I's within bracket with subsequent notice under section 148 of the Act has not been specifically dispensed with, and therefore the assessing officer cannot waive this obligation, which has a color of a statute. Therefore, the learned single bench on facts found that the condition for compliance as stipulated under section 151 within bracket 2 I's has not been fulfilled. Full stop. Having held so, it would have been well open to the learned writ court to have quashed the entire proceedings. But however, the learned writ court remanded the matter back to the assessing officer to process afresh from the stage when such irregularity has been committed and pass fresh order under section 148 capital A within bracket D of the Act in accordance with law after taking approval from the specified authority under section 151 within bracket 2 I's of the Act, and such order to be passed after following the due procedure of law. And the learned single bench has also fixed a time limit of 8 weeks for compliance of such direction. The impugned order was passed on 21st of June 2023, and the memo of appeal was presented before this court on 21/8/2024. Thus, the department were not diligent enough to file the appeal within the period of limitation. especially when a time frame has been fixed for the department to comply with the direction. That apart, we fail to understand as to how the department could be aggrieved by the impugned order, as the learned red court has not quashed the reassessment proceedings, but only set aside the same to the extent where the irregularity has occurred, and remanded the matter back to the assessing officer to rectify the defect. Therefore, the department should have been well advised to comply with the direction issued instead of filing the appeal at such a belated stage. For the above reasons, we find no grounds to interfere with the impugned order. Accordingly, the
My
appeal
lord,
fails.
may I pray for one indulgence, my lord? My lord, kindly the time for issuing notice further be extended.
All right. The time for compliance of the order passed by the learned single bench is extended by a period of 8 weeks from the date of receipt of the server copy of this order.
Your Lordship, I'm just requesting here that whatever if they want to take any action, Your Lordship, it should be according to law, Your Lordship, instead of extension of time. That's my humble prayer, Your
You are
Lordship.
not on appeal.
Your Lordship.
Next.
I'm grateful to Your Lordship.
Item number 12.
So there is a delay of 88 days, my lord.
How many days?
88 days, my lord.
That mega won't oppose.
Your Lordship, may I make a request, Your Lordship? Your Lordship, Mr. Kanodia is appearing in this matter. He is on legs in court number 5. Your Lordship may kindly take up the matter after vacation.
We will condone the delay.
Your Lordship.
We will condone. We have heard so and so, so and so. There is a delay of 88 days. As the delay has been properly explained, the same is condoned. EA1 of 2025 is allowed. Next.
For admission, item number 13.
Well, this matter was admitted by Lordship earlier, my lord. It should be fixed for hearing, my lord. It should
But
appear.
it's coming under caption for
don't know.
admission.
My lord, last order kindly says 24 November.
They
24
mentioned that the matter is covered by the judgment.
Your Lordship, it is a sugar cess matter. Your Lordship had, yes, Your Lordship had passed an order recently in the case of Diamond Beverages. Your Lordship, may I pray for a short passover, Your Lordship?
Give the judgment.
Your Lordship,
We passed an order last week.
Hello.
Who appeared in that matter? Manasi appeared. Sugar cess.
Topon. So far I can recollect. He must be in court number 5. Should I pass a message?
Yes.
to him? My lord,
BP Banerjee.
the sugar cess matter.
Sir, you give the paper book. Sir, where the question will be? Oh, second volume.
Copy after the judgment a copy.
Volume last 218. Sir, please take down. This appeal has been filed by the revenue, challenging the order passed by the Customs, Excise and Service Tax Appellate Tribunal, Eastern Zonal Bench, Kolkata, dated
This matter, my lord, is more than 5 crores, I think, my lord. This is threshold limit is above the, my lord. Kindly see, my
yes,
lord.
yes, we have dismissed it on merit, sir. Elaborate order. That is why you have to subscribe to Live Law and Bar and Bench so that you will know immediately. Or at least Rajshri, she should subscribe. In Excise Appeal number 76748 of 2019, dated 24/2/2022. The appeal was admitted on 24/11/2024 on the following substantial questions of law. Page 219 and 220, the questions are there, sir. A, B, C, D, E. You can cut and paste from the order. We have heard so and so, so and so. The above substantial questions of law was considered by this court in the case of Customs Commission of Commission of CGST and Central Excise, Kolkata South, GST Bhavan versus Diamond Beverages Private Limited in Section 9 of 2020, and the appeal filed by the revenue was dismissed, and the substantial questions of law were answered against the revenue. The operative portion of the judgment reads as follows. Please quote from page 3, sir. There's a para starting. Before we proceed to discuss, till the end, in the light of the above decision, this appeal has to be dismissed, and accordingly the same is dismissed, and the substantial questions of law are answered against the revenue. The same is next one also.
Your Lordship.
Only thing is, sir, that appeal number will next.
Grateful to your Lordship. Grateful.
Item 15.
Item number 15.
For the respondent, my lord.
Time for the appellant.
Lord, in this appeal, I may humbly submit, my lord, there is no framing of substantial question of law or any question of law for that matter, my lord.
It is not at frame.
No, my lord.
The Chaudhary will frame now. You frame the questions of law?
I believe so, my lord.
No, my lord. My lord, kindly consider.
Your friend says she has not framed.
Lord, they have in a contention, they have mentioned it.
Then you give a memo, tomorrow we'll take it up.
Memo, they have filed the grounds, my lord. They are.
No, from the memo,
yes,
they can give a and sign it by the council.
My lord, my lord. My lord, paragraph 20, page 21 of their GA, my lord. They have stated that in support of the contentions and or grounds aforesaid, reliance be placed on the following tabulated records. So it is admittedly they have given contentions and grounds.
Oh, what is the classification?
No, the classification, it is a settled issue, my lord.
Where is the order of the tribunal?
My lord, the page 25, your lordship will see of the stay petition.
My lord.
This is actually the second round.
Second round?
Yes, the conclusion of the first round, this honorable court has already decided the issue of classification.
My lord, what has not been indicated most probably.
One second.
My lord. Yeah.
Report keep.
Now the appeal was partly allowed in favor of the assessee company.
Only the penalties were set aside, but there was no decision on redemption.
But it's very, very confusing to read the
My
tribunal.
lord, I'll try to clarify it.
Then we'll do one thing.
Yes, my
We'll
lord.
list it after vacation.
Very well.
Meantime, you formulate your questions.
Very well.
By way of a supplementary affidavit, you bring it on record.
I'll do that, my lord.
And you serve an advance copy.
I'll do that.
And if you can prepare some dates and events.
I'll do that, my lord.
But then, if you're going to agitate a classification issue, whether an appeal will be maintainable.
Right. That admissibility issue was what I wish to present before your lordship.
Because earlier you filed writ petitions.
Right. So what happened, my lord? When this case arose the first time in the tribunal here, the bench here, so it was an out-and-out classification dispute. The tribunal decided against the assessee, relying on a decision of the other bench in Mumbai, which was upheld by the Supreme Court in relation to an earlier consignment. That decision of this honorable tribunal was challenged by means of a writ petition before this honorable court. And this honorable court, if your lordship peruses it, I can...
No, it remanded the matter.
You're all right.
No, in the...
So this honorable court decided the issue of classification, saying that whatever is on record, on the basis of the record, the classification change was not justified. However, in the interests of the revenue, this honorable court was of the view that on a limited scope, if the department could examine the test reports and satisfy certain conditions, which the honorable court prescribed, then only in that case, the classification could change. So he had decided the entire issue of classification. When the matter went to the de novo adjudication authority, he not only disagreed with the High Court decision, stating that the earlier Supreme Court judgment or the appeal confirmation would gain precedence, and redecided the entire issue of classification, imposing penalties, enhancing penalties, and imposing a redemption fine, which was not even there in the original adjudication stage. This matter was appealed before the tribunal, and the limited issue was res judicata, principle of judicial discipline, and natural justice. The de novo adjudication was supposed to be completed in 12 weeks. They did it in 7 years. So the issues with which the assessee has come before this honorable court is the same. It's limited. Now, insofar as classification is concerned, what this honorable court had done, why it migrated away from that decision of the Supreme Court. The assessee came before this court and presented an earlier decision of the Supreme Court, which was a larger 3-member bench decision, where on the exact issue, the Supreme Court had said that there is no change in the product. So this honorable court said that, even acknowledging that other consignment, saying that every consignment has to be assessed afresh, and that it's not a hard and fast rule that one consignment has been assessed in a certain way, so subsequent consignments will also be assessed the same way. So this honorable court, swayed by the earlier larger bench decision of the Supreme Court, decided against the tribunal order and in favor of the assessee, holding that the classification was right. Now, when the matter went to the de novo adjudication authority, he presented that all those test reports, they were never prepared. They didn't have a single test report. So naturally, the condition of the High Court could not be satisfied. So he went around that problem by saying that the Honorable High Court's judgment is not binding upon him, and that he prefers to rely on the Supreme Court confirmation. So this is how the circuitous way in which...
But the High Court judgment was inter-party. The same petitioner.
Same petition, same consignment. It's a case of res judicata. Ordinarily, res judicata doesn't apply in tax cases. But in this case...
But then, if there are decisions which say that if it is the same product...
Yes, my lord.
And say some bills of entry were assessed in a particular fashion.
Right.
Consistency should be maintained.
Should be maintained. Yes. So here what had happened is, in the earlier consignment that was intercepted in Mumbai. So one of the first observations there is that in all the previous consignments, the classification was done by the department and the assessee in the way that the assessee has done in this case. But what happened is they introduced an exemption. As soon as the assessee availed the exemption, the DRI stepped in and changed the classification. Now, this honorable court changed it back to what it was before.
So principally, you will be arguing that this classification issue cannot be reopened.
Cannot be.
And if it all to be reopened, the parameters specified by
limited scope.
the that was a division bench judgment or single bench judgment?
That was a single bench judgment, my lord.
They didn't file an appeal.
They did not file an appeal, and they participated in the de novo adjudication.
And what was the product which was imported?
Shrimp eggs, my lord. Shrimp eggs.
Live or
so these are all live shrimp eggs. They have live embryos inside of them. So what happens is the assessee was an out-and-out trader. He used to import these shrimp eggs, and then he would sell them to the fisheries and the hatcheries. Now, the hatcheries would then incubate these eggs and then hatch them. So what the case that the department made out was that even if, as per the technical literature and information, trade parlance appears to indicate that prawn feed, which is the issue in dispute, if someone goes to the market and asks for prawn feed, they're going to get shrimp eggs. So that's how it is understood. Prawn feed. So they are actually feeding the fish using shrimp eggs. So they are feed for the fish. So the fisheries, the hatcheries, they want these eggs because they hatch them, they take the larvae out, and then the larvae is then fed upon by the fish. So what the assessee was saying is, in trade parlance, if one goes to the market and applies for prawn feed, they're going to get shrimp eggs in containers with instructions on how to hatch them. And this is acknowledged even in the tribunal decisions, where in the technical literature, these shrimp eggs are referred to as prawn feed. Now, what the tribunal said is that they went into the scientific description that if the larvae is coming out of these eggs, they are not the same as the eggs, and therefore they are a different product, and therefore the larvae is prawn feed, the shrimp eggs are not. Now, the Honorable Court said that the incubation process is basically enhancing the hatching, and this is based on the Supreme Court judgment, that the incubation is only enhancing a biological process because it is intrinsic to an egg to ultimately hatch. So this Honorable Court, applying the Supreme Court judgment, came to the conclusion that ultimately there's no distinction between the larvae and the eggs, and the classification need not have changed. So the prawn feed is for the shrimp eggs, that's also prawn feed.
This analogy, I think there are decisions on other products.
There are other products as well, but insofar as specific to prawn feed, this Honorable Court has given a decision relating to chicken eggs. So there was a larger bench decision of the Supreme Court on incubation of chicken eggs and hatching them. And there the assessee, it went against the assessee. The assessee had said that I'm incubating, there's a man-made intervention, and therefore something is emerging due to my intervention. And the Supreme Court said, what that is doing is it's enhancing the process, but biologically it is intrinsic to an egg to hatch. That doesn't change.
So that was a converse case.
So that was a converse case, and that was applied by this Honorable Court in favor of the assessee in this case.
Good. The learned advocate appearing for the appellant is directed to file a supplementary affidavit along with the substantial questions of law, which according to the appellant arise for consideration in this case. Let an advance copy of the same be served on the learned advocate appearing for the respondent. Give a date immediately after vacation.
Very grateful, man.
There is one decision that was a case of an export. Frozen frog legs.
I'll make a note of it.
Frozen frog. Don't know what was the ultimate decision. Actually, the frogs are it's grown.
Right, man.
And what is being sent or exported is only the leg.
Right.
It was long time back.
But this would fall within those line of cases where there is a development of the product.
That's not the issue here.
Yeah.
According to you, that classification is put at rest by the
Honorable
in
Court.
order
Yes.
passing the writ petition.
In fact, I will not be asking this Honorable Court to go into the issue of classification at all. It's only on judicial discipline and whether the department is bound by it.
I don't know, 16.
I'm led by Mr. Kaitan.
Well, at 16, I have some difficulty. Actually, the brief is missing, well, today.
We will give you one brief.
No, the appeal does not lie before my lords, my lord, because the question is regarding my lord, the classification of the service.
Oh,
and with that,
you are not going to Supreme Court, Mr. Banerjee. Why?
Well,
you can appear online. You ask them to file and you appear online.
But we are not entangled over there.
You are not entitled to. Service by club or association or insurance auxiliary service.
my lords. But I paid tax under the club or association service from Lord May 2015. They're asking Lord under this insurance auxiliary service for the earlier period as well. So Lord, clearly there's a period during which I had not paid any tax. That's 2004-5, and from Lord and part of 2005-6, and then from 2005 Lord I paid under this club or association service. And Lord, linked with that, Lord, where I'm classified, the entitlement to credit will also depend whether it's input service or not. Because I had this club, Lord, Medicare Service Club under the company, Lord. It's my business name. Lord, I took in members. Lord, I obtained group insurance for them. The insurance policy was in my name. Lord, I paid the insurance premium. On the premium, Lord, the insurance companies paid the service tax. So I took credit of that. Now they say that the policies are in the names of the policyholders, and it is contrary to the policy document itself. So they want to treat me as an insurance auxiliary service provider.
But the assessee is the insured.
No. Yes, Lord. I am the Medicare service.
You have got a group insurance, and in which there are several members. But the policy stands in the name of the assessee.
In my name.
But it's a classification.
Well, next, well, at any day, well, I have some notes written, well, that is little handicap today. Kindly
because in the adjudication order itself or in the show cause notice, the first issue is why the service provided by the assessee should not be classified under the category insurance auxiliary service instead of membership of club or association.
Yes. Well, at any day after vacation, we should.
But then there's one more thing, Lord, the assessee, there's an Section 7 petition has been admitted. But if it is held to be not maintainable, Lord, then it will go on that ground. Otherwise, Lord, in case my lords are of the view that Lord, page 10, Lord, if my lords are please.
So if it is admitted, you can't proceed in terms of that recent decision. In which you are carrying this is Gawai's decision, which says that they can't proceed. It has extracted all the. We followed that and we passed a note. All right, we'll give Mr. Banerjee at the request of.
I'm ready.
Absolutely.
Item number 17.
My lord, I am for the petitioner, my lord. I am happily praying for short passover, my lord.
So it's not possible.
My lord, I'm for the respondent, my lord. A copy may be served to me, my lord. During the course of the day, my lord, because
My lord, I have already served, my lord. The affidavit service
department,
was already
not to the department concerned with us. So they have.
If you have a soft copy, you can give them. Soft
My lord, my
copies.
lord, my lord.
The learned advocate for the appellant is directed to serve copies of the appeal memorandum along with the stay petition and annexures on the learned standing counsel appearing for the respondent department. By tomorrow, you can serve?
Yes, my lord.
By tomorrow, list after vacation.
Grateful.
I don't know, 18.
It was a refund claim, is it?
My lord, there is a refund claim, lord. My lord, on behalf of the appellant, my lord, we are challenging the order of the tribunal. My lord, this is an order of the tribunal which is to be read with the rectified order of the tribunal. There had been certain factual discrepancies; those have been rectified. My lord, the only challenge is with respect to the direction of remand that has been made in the final order, and thereafter factual discrepancies rectified, and my submission is, my lord, that the remand direction was made because of the incorrect fact that was recorded. Subsequently, the factual discrepancies stand rectified, and therefore the direction to remand should also have been recalled. However, my lord, that has not been done. This is the sole issue which is before my lord. Now, my lord, where the refund arises from, my lord, that is in my favor. They have granted the refund.
According to you, if the case is covered by the earlier decision of the coordinate bench, and it is a case of where there is no unjust enrichment, your application should have been allowed.
Yes, my lord. And my lord, why no unjust enrichment, my lord? Because this is a case where I have paid service tax under reverse charge mechanism. It's established law, my lord, that under reverse charge mechanism, there is no question of unjust enrichment because I don't have the opportunity to collect tax from anyone. I have paid tax out of my own pockets and I subsequently claim credit of that.
Let us see the order rejecting your application for refund.
My lord, there is no order which has, my lord, that rejection of order has been done at the commissioner appeal stage. Subsequently, the tribunal has allowed that.
Set aside that.
Yes, that has been set aside.
Yes.
On merits, it has been allowed in my favor. My only challenge is with respect to the direction for remand for verification.
To entertain the claim for refund filed by the appellant on its own merits. So the adjudicating authority rejected the application on the ground of on merits.
On merits.
So having set aside that, you said that refund should have been ordered. That's your prayer.
Yes, my lord. But in the order of the tribunal, which is of September 2024, they have allowed my appeal, my lord.
That's what page 43.
Yes, my lord. Along with allowing the appeal.
Find in this case, para 7, appellant paid license fee and so and so. Observe that the issue of time limit is examined by the tribunal OSI system and found that for transitional provisions under so and so, limitation has been done away with. Only thing required for refund is whether, under the facts and circumstances of the said case, unjust enrichment is attracted or not.
And whether, as far as unjust enrichment is concerned, department never raised the issue. It is the first time that it is appearing here, my lord.
You show the commissioner's order.
Yes. Let the commissioner's order, it starts at page 33, and the relevant portion of the order.
Page? Commissioner appeals order.
Page 78, my lord. Page 70. I stand corrected, my lord. Page 78.
It starts at page 75. Commissioner appeals.
My lord. But this commissioner, my lord. Commissioner appeals.
This is appeal. Adjudication order. Where is the order in original? Order in
original. The order in original.
No delay. No delay. No delay. It is there. But the tribunal order.
Lord would find the order in original in the
Where?
volume 2 of my stay application.
Page.
Lord, it is at page.
You should note down the page numbers before you open. That's basic requirement is to make notes before you come to the court. And here you are wading through the entire paper book, I mean, stay petition to find out where the order in original.
Page number 209, my lord, it starts. The operative portion is at page number 221, my lord. But the reason for rejection of refund was that, my lord, at the time of payment of service tax, the service tax was paid in a delayed manner. My lord, the liability to pay service tax arose because, my lord, we had procured license to sell in India from Ipsen Malaysia, my own company in Malaysia, and therefore I had a liability to pay service tax under reverse charge under service tax law. That service tax was paid subsequent to the implementation of GST, and therefore, my lord, I could not have. There is no dispute regarding eligibility of SENVAT credit, but I could not, because GST was already implemented, I could not have taken that credit in my SENVAT register. Therefore, in terms of the transitional provisions of GST, I can claim refund of that, and such kind of refund I had applied for, my lord.
How does he reject it?
Yes, my lord. The rejection is on the ground of the delay, my lord. They say, yes, my lord, page 222, my lord, para 5.3.1 at the bottom.
Hmm.
5.3.1, thereafter, my lord. Then he records. Then, my lord, at page 225, he records his findings in para 5.3.8. There are some apparent discrepancies found in the submission. My lords have found it, my lord. 5.3.8. Here is some apparent discrepancy found in submission of SSC regarding admissibility of refund under 142 subsection 9 clause B of CGST Act, which state that where any return furnished under existing law, that is service tax law, namely Rule 7 capital B, after appointed day, that is 1st July 2017, but within time limit specified for such revision within 90 days from the date of submission of original ST3 return filed on 28/4/17 for the period half year ended March 2017. Here SSC have admitted that due to an inadvertent error, Ipsen India missed out to make the payment of service tax liability under reverse charge mechanism during the month of March 17, and also missed to show and get it reflected in service tax return filed for the half year ended March 2017 by the due date of 30th April 2017. But this is the key dispute, my lord, because of which the refund is denied. And my lord, they are referring to the provision of 142 subsection 9 clause B. My lord, there is another provision, that is 142 subsection 3, my lord, which does away with the limitation. That
the tribunal has noted.
That the tribunal has had.
In the earlier decision, which has been referred.
Yes, my lord.
But where is the question of unjust enrichment?
There is
That
no
was
question.
never an issue.
It is not there, my lord. And in factual circumstances also, my lord, it cannot arise.
It can never arise. That is why in the quoted decision of the coordinate bench of the tribunal, direction was issued to effect refund within 60 days.
Yes, ma'am. And my lord, the judgment which has been referred, that is OSI systems, in my case of September 2024, OSI system also has similar facts. Now, my lord, while quoting the judgment of OSI system, the word no unjust enrichment, that no is omitted. That is why unjust enrichment arises. From there it comes. Also in my facts, my lord, in my fact from my...
So the question of remand itself doesn't arise.
My lords.
Where is to see that mistake has been rectified by the tribunal.
Yes, my lord.
He filed 154, page 36.
Yes, my lord.
There is an extract of the case law on OSI. In the extract, the word no has been omitted while extracting the extracts from the order in the 7th line. Further, applicant submits para 7 of the order. There is mistake apparent on the. In the extract, the word no has been omitted. Since the appellant has not reversed the credit, but has paid the service tax under reverse charge mechanism, appearing for the appellant, submit tribunal is required to modify. We find there are mistakes apparent on record. Accordingly, extracted portion. Para 7, we find a case reverse charge mechanism. Then consequently, his appeal should have been allowed as prayed for.
That was my prayer, my lord, in my application for rectification of mistake. That has been considered and denied, my lord. In para 4.
Para 4, page 38.
My lord.
See, because in the extracted portion that no was missing. In the first order, the tribunal came to the conclusion that that issue has to be decided.
On facts also, instead of recording that I have paid service tax under reverse charge, they recorded that I reversed the service tax.
Where is your rectification petition?
Yes, my lord. My rectification petition is there. That is at page number 267, volume 2 of my GA, my lord.
Sir, please come. This appeal has been filed by the assessee under section 35 capital G of the Central Excise Act 1960. Within bracket the act. It should be 1944. You have said Central Excise Act 1962.
But it's wrongly recorded.
It is wrong. 1944. Challenging the order passed by the Customs, Excise and Service Tax Tribunal in Service Tax Appeal number 75798 of 2024, dated 4/9/2024, and the rectification order in Service Tax within bracket ROM application number 75650 of 2024, dated 11/2/2025. The assessee has raised the following substantial questions of law for consideration. Page 30 and 31, 1, 2, 3, 4. We have heard so. The assessee preferred the appeal before the tribunal, challenging the order passed by the Commission of CGST and CX, Kolkata, Appeals number 1, dated 6/12/2023, by which the Commission of Appeals affirmed the order in original, original, dated 28/2/2019. By the said order in original, the adjudicating authority rejected the appellant's claim for refund for violation and misinterpretation of circular number 207/5/17 service tax dated 28 September 2017, read with section 142 within bracket 9 of CGST Act 2017, Rule 7 of the Point of Taxation Rules 2011 and Rule 7 capital B of the Service Tax Rules 1994. The provision envisaged under section 174 of the CGST Act 2017 was also made applicable to the said order. The appellate authority concurred with the views taken by the adjudicating authority and rejected the appeal. The correctness of these orders were questioned before the learned tribunal. The appellant, among other things, contended before the tribunal that they would not fall within the scope of the circular dated 28 September 2017, wherein revision of service tax return for the quarter ending June 2017 has been allowed till July 2017. No, sorry, sir. You strike out that part. The assessee relied upon circular number 341/34/2010 TRU, all capital, dated 31st March 2011, where the applicable point of taxation has been illustrated by way of an example, in respect of cases where part payments are made for receipt of services. Appellant also contended that the circular dated 28 September 2017 was issued to clarify the position as to the details of credit arising out of service tax paid under reverse charge mechanism after 30th June 2017 would be reflected in the service tax return or in the transitional forms under GST. Further, the assessee contended that the service tax paid under reverse charge mechanism was eligible credit and the same was indefeasible in nature, and in this regard, placed reliance on the decision of the Honorable Supreme Court in Collector of Central Excise, Pune versus Daiichi, DAI, space ICHI, space KARKARIA Limited, 1999, 112 ELT 353 within bracket SC. Further, the assessee contended that they are eligible for refund of SENVAT credit as claimed in its refund application in terms of section 142 within bracket 9 within bracket small b of the CGST Act. Which makes it apparent that upon fulfilling the conditions listed thereunder, the amount which is in the nature of admissible SENVAT credit or which is refundable, the same becomes refundable in cash under the existing law, notwithstanding anything contrary contained in the said law other than the provisions of subsection 2 of section 1 capital B of the Central Excise Act 1944. An alternate submission was also made that their refund claim is also eligible to be allowed in terms of section 142 within bracket 3 of the CGST Act. The grounds canvassed by the assessee did not find favor with the appellate authority, who rejected the appeal, which was put to challenge before the learned tribunal. The learned tribunal accepted the case of the assessee, and in doing so, followed the decision of the coordinate branch of the tribunal in Circo Flow Technologies India Private Limited, sir, it is in page 41, versus the Principal Commissioner of GST and Central Excise Coimbatore, 2022-VIL-15-Sestat-CHE-ST and OSI Systems Private Limited versus CCT Rangareddy, 2022 within bracket 9 TMI 801-Sestat Hyderabad. In the order passed by the learned tribunal dated 4/9/2024, the judgment in the case of the relevant paragraphs of the above two judgments were extracted. And agreed with the contention raised by the appellant that the decision in OSI Systems Private Limited would be applicable to the instant case, to the assessee's case. But however, in the penultimate paragraph of the order dated 4/9/2024, the tribunal, while setting aside the order and allowing the appeal, remanded the matter to the adjudicating authority for the purpose of considering whether there is a bar of unjust enrichment. To be noted that the plea of unjust enrichment was never the case of the department, as could be seen from the show cause notice as well as the order of adjudication and the order passed by the appellate authority. The mistake occurred on account of the fact that while extracting the decision in the case of OSI Systems, the word no, inverted comma, before the word unjust enrichment occurring, no, unjust enrichment was omitted. Consequently, the tribunal appears to have been of the view that the only point to be considered is whether the bar of unjust enrichment is applicable. Having noted this error, the assessee filed an application for rectification of the order dated 4/9/2024. The applicant pointed out two errors which were apparent on the face of the order passed by the learned tribunal dated 4/9/2024. The first being that the tribunal has observed that the assessee paid the license fee on 17th March 2017 when the erstwhile provisions of the service tax was in force, but reversed the credit on 26 September and October 2017. This finding, according to the assessee, was erroneous since the service tax paid subsequent to the implementation of GST, which was of which refund was sought for, was paid by the assessee under reverse charge mechanism, and therefore what was recorded by the learned tribunal was factually incorrect. The next aspect which was next error which was pointed out was the omission of the word no in the extracted portion of the decision in the case of OSI systems. The said application for rectification was considered by the tribunal and the case of the assessee was accepted. And the word no was inserted in paragraph 3.1 of the order passed by the learned tribunal dated 11/2/2025. In the rectification application, one other prayer was made by the assessee to grant refund without subjecting the assessee for further verification by the adjudicating authority. This prayer was rejected by the learned tribunal in paragraph 4 of the order dated 11/2/2025. Therefore, the assessee is on appeal before this court. The learned tribunal, having accepted the fact that there is an error apparent on the face of the order, in as much as the word no was missed out while extracting the relevant portion of the decision in the case of OSI Systems Private Limited, the tribunal ought to have noted that the consequence thereof was to allow the appeal of the assessee and direct the adjudicating authority to grant refund within a time frame. In fact, the factual position in OSI Systems Private Limited is identical to that of the case of the assessee. Therefore, the conclusion of the learned tribunal that the assessee sought for modification of the earlier order dated 4/9/2024 is incorrect, since if the word no is inserted in the appropriate place, then the judgment in OSI systems will fully apply to the facts and circumstances of the assessee's case, and consequently, they would be entitled for refund. In the light of the above, the appeal filed by the assessee is allowed, and the order passed by the learned tribunal is set aside, and the substantial questions of law are answered in favor of the assessee, and the adjudicating authority is directed to grant refund within a period of 60 days from the date of receipt of the server copy of the software.
Well, by following all the required formalities, because for refund there are some formalities which the SSC has to undertake.
They'll finish him off.
Well, all that has
If we add that one line, they'll finish him off.
Well, in accordance with law.
Nothing is against law.
We'll
stop. Sir, you are waiting for which matter? Second half. Oh, yes, you please. Yes. We will note down. You can give the serial number. We will actually. No.
Well, I permit to mention one matter. We are facing difficult problem with the income tax department. Let the matter Shivam Dhatu let me appear tomorrow. Because panel was expired, they are saying CBDT already given extension, but we are asking for the copy. They are not.
Tomorrow, list the matter tomorrow. First case. You please inform the additional Solicitor General.
Yes.
And you also send a email to the Commissioner Judicial.
Okay.
Saying that the matter has been mentioned, it is going to be listed tomorrow.
I'll do.
What about the other states?
I don't know, Malad. This is a huge problem we are facing. We thought initially a doctor came and give us perfect medicine, but absolutely wrong.
I thought he was very efficient officer. He mentioned. But can you check with your counterpart in Orissa or Jharkhand?
I don't have any knowledge, but the problem is here serious. We are working here, but CVDT extension order was not given to us.
No, then you do one thing. You ask Mr. Vinay Sharaf for any phone number of Jharkhand advocate who appears for the department, because he goes to the Jharkhand.
In the meantime, we are also
you can also check up what happened to their panel, whether extension has been granted.
Let it appear tomorrow.
Or all of you go on pen down. Pen down.
Well, next few matters I had, well, it will take before vacation.
Which or after?
Item number 20, 21 and 20.
No. Where are you going, Jit? Where are you going?
I'm not going.
Why you're not going anywhere?
Well,
sir, whatever you earn, you need to spend, sir. You need people like you you open the newspaper of this travels, Baumal and Lorry, SOTC.
One page.
One full page.
Lots of draftings are pending to be completed during this.
That will always be there. At least for 5-7 days you have to.
But going to my maternal uncle's home for a few days. But that's it. That's my vacation.
So we will not take up. That is item 19.
20, 21, 22.
20, 21. Sir, this foreign exchange appeal will go before the other bill.
Right. Now that's why I was.
Second evidence.
It will go before
SAFEMA.
All coming from SAFEMA tribunal should go before.
Yes, you see that notification.
Yes, 21 and 22. These are orders.
21 and 22. List before the appropriate Honorable Division Bench. No, list before the Honorable Division Bench having determination. Because last line says anything from the SAFEMA tribunal.
Yes. Any order for appeal from any order of SAFEMA tribunal. I've seen that. Deeply placed. 20 after vacation.
20 and 22 will go to
appropriate bench having determination.
My lord, under compelling and extraneous circumstances, may I make one prayer before your lordship, my lord? This matter pertains to a tender dispute, which my lord knows that these are very extremely urgent matters, my lord. I have genuine urgency. I am not exaggerating it. Now, this matter came up before Honorable Justice Amrita Sinha on 19th, and it was made returnable on 21st, that is today. Now, Honorable Justice Amrita Sinha will not be in session till the summer vacation, ensuing summer vacation. Now, what has happened, my lord? I have already prayed for assignment of this matter. If my lord kindly allows us leave to make
No. Today the urgent determination.
urgent determination has been given to Honorable Justice Gauranga Kant. I had mentioned there, his lordship is of the opinion that his lordship list is very heavy. His lordship is not going to take up any matter.
Because I saw the order sheet also. You had enclosed it along with your letter. Already affidavits have been called for. It's
Yes,
a hearing matter.
hearing matter, I have urgency, my lord, because work is
Then
going on.
Then you move the vacation court. We can grant permission.
My lord, my lord.
You get that letter and ask.
I have a copy of that.
No, the original letter is lying with the
My lord.
OSD. You can permit it to move the vacation court.
I'm extremely.
Mentioning upon notice? No.
No, notification. No. I shall inform. I shall inform.
You inform and write.
I shall positively inform. I undertake to inform.
Mention. Leave has been granted to move the vacation court.
My lord, I am extremely grateful to Lord.
Appellate side, Delhi list, serial number 1.
I appear for the appellant, Your Lordship.
My lord, I am for the
So
bench.
this appeal has been filed, assigning an order passed by the Honorable.
This is for extension of interim order.
Extension of interim order on last occasion on 13th of May, the interim order was extended for 2 weeks.
2 weeks, my lord, your lordship.
We will take it up immediately after vacation.
Yes, my lord, date may be fixed, but otherwise,
Going on.
Yes.
So let the matter appear on 18th June. The interim order already granted is extended till 25th June.
Great.
My lord, may I submit the affidavit in opposition?
Affidavit in opposition is taken on record.
Much obliged. দিয়েছি ওনার কাছে দিয়েছি
Contempt. My lord. This is a contempt application pursuant to your lordship direction and kind leave. My lord, I've taken the photograph of your lordship brief, and my lord, I'm serving the affidavit of service. I serve both the office of the learned advocate general.
My lord, I am appearing for the alleged contempt. There is an express order, my lord, directing to reinstate the petitioner as an Anganwadi worker. My lord, will find my lord's order is dated 6th of August 2015, starts at page 25, and the operating portion is at page 30. My lord, this is an order of 2015, my lord. My officer, my lord, could not communicate me if the order was at all served with it, with the office.
Yes, my lord.
My lord, what I am on today, my lord, we have to take steps in terms of compliance, for compliance.
Whether any appeal has been preferred?
There is no appeal, my lord. There is no appeal as on date. But what I have asked the alleged contender, my lord, he should immediately call upon the petitioner, a person hearing, thereafter, my lord, pursue the records of the case, and my lord, act in terms of this order. My lord will not dispose of the matter.
We'll keep it.
Kindly keep it pending. Allow us to come back before your lordship.
We have heard so and so learned advocate appears for the alleged contemptor. It is submitted that the alleged contemptor has been advised to take note of the directions issued in the judgment dated 6/8/2015 and take immediate steps for compliance of the order. The Learned Government Council seeks time to report the further course of action. No, report the course of action which will be taken by the alleged contemptor. Let a report in the form of an affidavit. Sir, you file a report.
I will.
Let a report in the form of an affidavit be filed by the alleged contemptor on the action which has been taken for implementation of the judgment dated 6/8/2015. List the matter on 18th June.
Serial number 3
is a similar matter.
Similar matter is the affidavit of service.
Same order in the item 3 also.
We are grateful, my lord.
My lord, grateful. Your lordships, my lord, permit me to take a copy from your lordship's brief. Then I, my lord,
Because he lost the old matter.
Pursuant to your lordship direction, if, my lord, the old ladies, my lord, the persons can get the job.
Otherwise, he has to apply for certified
No, no, my
copy.
lord.
That will take another 2
I
years.
am very grateful, man.
For the ends of justice, my lord, your lordship has allowed.
Grateful. Serial number 4.
The judges are here in all the matters. Then 4 to 7, you say, since the honorable judges, judges who had passed the order in these contempt passed the order against which the contempt on which the contempt application has been filed, alleging disobedience, are available in the High Court at Calcutta, and therefore the department shall list the matter before the appropriate honorable division.
Number 8.
Much obliged, Lordship.
Item 6, my lord.
Really.
I'm appearing item 6, my lord.
Yeah, because the judges are available, so it will go before the concerned judge.
My lord, all the honorable judges who passed the order retired, my lord.
Oh, item 6.
Item 6, my lord. That's why I could not take it.
Because they verified and they saw at least one judge was there.
No, my lord, no. Nobody.
None of the judges.
Both the honorable judges.
Sorry. Item 6, they have not complied.
My lord.
What is the order?
My lord.
Yes, madam.
My lord, can we come to the last paragraph of the order, my lord?
Lordship, I was just trying.
Paragraph 17.
What is your instruction?
Mine.
My lord, thereafter, my lord, they went to the Supreme Court. Honorable Supreme Court dismissed the SLP. My lord.
Lordship,
आप बोलिए दे दो ऊपर अपना नहीं दे दो.
So
after my dismissal, petition has been reinstated.
Petition reinstated.
But the back wages, as far as paragraph 17 can see, I'm placing for a while, man. Paragraph 17 of the judgment, my lord. Therefore, we have no option left to it except to set aside the impugned order. In the result, the instant appeal is allowed. Judgment passed by the single judge as well as the order of the disciplinary authority of CISF are hereby set aside. The appellant be restored in its original position in service if he has not attained the age of superannuation by this time, and if he had already attained the age of superannuation, then in that case, all financial benefits should be given to him, as if he was never terminated within 3 months. Well, that has not been done, my lord.
But what about financial benefits?
That is my lord.
He has been reinstated with financial benefits, lordship. What has lordship? But what has happened is, lordship, on the same day of filing the contempt application, my learned friend had filed an application before the bench for certain prayers.
What?
On the same day, the contempt application was filed in one hand, and I find Can 4 of 2022 has been filed where, in the FMA, where the petitioner has paid for financial benefits.
All right, that we
there,
can drag that can also, there's no problem.
Yes.
But then you have to give the financial benefits.
My lord.
Lordship,
Where is the record to show?
I've just looked, I mean, briefly, Lordship will kindly
You get written instruction?
I'll get instructions, I'll get.
The
And what I find is there was no notice of contempt.
No, we have not issued notice.
No, not lordships. My learned friend, before filing a contempt application,
They didn't issue a notice.
that neither did they issue a notice. I don't
The
find
contempt
that.
petition has been filed alleging disobedience of the judgment dated 16/7/2015 in FMA number 894 of 2006. By the said judgment, The appeal filed by the petitioner herein was allowed. Order passed by the learned single bench was set aside, as well as the order of the disciplinary authority of CISF was set aside. The appellant / petitioner was directed to be restored in his original position in service if he has not attained the age of superannuation by the said time, and if he had already attained the age of superannuation, then in that case all financial benefits should be given to him as if he was never terminated within 3 months from the date of communication of the order. As against the judgment, the Union of India and others preferred appeal to the Honorable Supreme Court in special leave to appeal number CC 2838 of 2016, which was dismissed by the Honorable Supreme Court on 19/2/2016. The learned standing counsel appearing for the respondent / alleged contemnor submitted that after the dismissal of the special leave petition, the appellant / petitioner has been reinstated. The learned advocate for the appellant / petitioner submits that though the appellant has been reinstated, the financial benefits have not been granted. In this regard, specific instructions, written instructions shall be obtained by the learned counsel for the respondent from the appropriate authority of CISF and placed before this court on the next year.
I'll get the instructions, Lordship. And
It's the
Lordship,
matter on 18th June.
18th June. And Lordship, that we were not given any notice for contempt.
No.
That is also, the Lordship will kindly record that. I mean, it's not in, the contempt petition doesn't contain any notice.
No.
Lordship.
You get instruction. We said only alleged.
Instruction. Yes,
My lord,
Lordship.
my lord, in the meantime, content marks are retired. May I incorporate the name of the new incumbents, my lord, if it is required?
Not required.
My lord.
That CAN 4 has been filed, is it?
CAN 4 has been filed, yes, Lordship.
CAN 4 of 2024, is it?
2022.
2022. Filed in FMA 894
Filed
of
in connection
2006
with FMA 894.
shall also be listed along with this contempt
Yes,
application
Lordship.
with the original FMA file. Next.
This is my appeal, my lord. There's a delay of 102 days, my lord, in the appeal.
Respondent.
Respondent, we have served it, my lord. My lord,
Mr. Jishnu Chaudhary, Shreyas Basu Dasgupta.
We have served them, my lord. My affidavit service is ready, but it could not be affirmed, my lord. My lord, they refused, my lord. My lord, we directly sent it to the, my lord, respondent.
August 2024.
What is this, sir? Some deficiencies are there.
My lord, deficiency is here, my lord. I'm telling you, my lord, this is the case, my lord, where, my lord, on the date of payment of the tax, time limit is 2 years, my lord. You have to make the application, refund application. What they did, my lord, they didn't do it, my lord. We have
They did it.
No, they did it.
Defective.
The defective, then my lord, we issued the deficiency memo saying the annexure B is incomplete. You know, that document is annexed.
No, you selected the option supporting documents attached are incomplete. You didn't give him a list of deficiencies.
No, but that is not, my lord, in portal.
What to do?
That option is.
We will permit him to do manual filing.
My lord, one thing, my lord, I'll tell you, lordship, my lord. Now, kindly appreciate. This is the 3 deficiency memos are there.
We passed an order like that in case of transitional credit, and manual filing was permitted. Appeal to Supreme Court dismissed. The department has accepted. Now the present GST Council decisions are all supportive to the taxpayer. Sir, what is important is the substance over form. How many appeals are defective filed by the department? This is also defective. There is a delay.
My lord, here
presentation form is defective. We give permission to amend.
My lord, my lord. Now question is that, my lord, suppose, my lord, today I file the appeal with a wrong presentation form. I come to your lordship, my lord, after 2 years. I'm praying, my lord, kindly.
We will grant it.
My lord is granting because my lord has inherent power. Now, my lord, statute permit me, my lord, not to allow them after 2 years. Then what is the effect of the statute? Statute says that you come immediate relevant date from the relevant 2 years, the relevant date, my lord.
But the problem is already what is the date on which the deficiency memo was uploaded?
My lord, May 2023.
23.
My lord, the period was 3 periods were there. One is 2021, another 21-22, then 22-23. My lord, my question is that, my lord, the date when he my lord, paid the tax in respect to ITC, he wants to refund, my lord. From that date, 2 years, the period he have to make the application. My lord, now question is that
his application was not rejected on the ground it was deficient.
No.
A return or a deficiency memo has been given. Once a deficiency memo is issued, it presupposes that the assessee can resubmit upon rectification.
Grateful, my lord. Now, my lord, can I appreciate what he did? He come in writ petition in August 2024, waited for years.
The time limit is there, Rule 90.
By this process, everything will be, my lord, infructuous. A litigant must be vigilant. His money, he wants to get it refunded, but he waited for years. The money is not required for him, my lord.
Same argument we will use.
My lord, in our case, if there is any money due to the government, well, immediately we face to the right to the government, please give the money.
The impugned order was passed on 3/10/2024. You ought to have filed the appeal on or before 2/11/2024, but you filed the appeal on 11/2/2025. Dismissed. Condemnation delay. Same argument. We will say this is the argument of the learned senior standing counsel. If this argument is put against the appellant, this condoned delay has to be.
But for academically, I tell you, lordship, my lord, if you look and see section 54, proviso kindly sees, my lord. Rule 90 kindly sees, my lord.
That is why they relied upon Rule 9.
Rule 90, my lord, 90.
90
sub rule 3.
That you are bound to disclose the deficiencies. So therefore, you have to amend your portal or the web page, giving supportive documents attached are incomplete. You click on that, there will be a drop box where your officer can fill up 1, 2, 3, 4, 5. Easily it can be done.
But my lord, in the deficiency memo, we have stated the annexure B is.
You want only tax, sir. You are not worried about the taxpayer.
No, I am worried. I am always worried, my lord. tax should be paid by.
Sir, give the rules. Rule 90. Rule 90 you take, please.
Rule 90, sub rule 3, my lord.
We will say it's a peculiar circumstances.
No precedent. Disposed to not disposed.
And my lord, not only that, it is a case, my lord, when immediately, my lord, the application has been, my lord, incomplete, Manu has immediately, my lord, credited to his account. He knows.
So proviso to sub-rule 3 says
My lord.
the time period from the date of filing of the refund claim
My lord.
in form GST RFD 1
My lord.
till the date of communication of the deficiency in form GST RFD 03
My lord.
by the proper officer shall be excluded from the period of 2 years as specified in subsection 1 of section 54. If
My
that is so, this 2-year argument on the 2-year limitation also goes. Because when the deficiency memo was
May 2023, my lord.
23.
My lord.
So obviously, he has immediately come to the court.
No, my lord. I am subject to your lordship correction, my lord. Well, 54.
Assuming you had complied with sub-rule 3, still this period from the date of application till the date of communication
Has to be excluded.
Excluded.
Yes, my lord, that the period means, that means, my lord, suppose he made the application in, my lord, May 2024-23, and my lord, we issued the deficiency in May 2023 after 10 days. These 10 days will be excluded from the relevant period, the 2 years, that is section 54, my lord.
All right. When did he file his form GSTR
Well,
RFD 01?
Well, it was filed, my lord.
কোথায় কত পেজ আছে বলো? Page 50.
My lord, page 50 kindly take some, my lord.
19.5 to
There are 3 applications.
3 applications.
Date alone you give.
19.5
Well, 19/5/2023. See, my lord.
23.
My lord.
25 2023.
25.
205 and 2023. And another is 22nd May 2023.
19/5/23, 20/5/23, 21/5/23,
22.
22/5/23. When did you issue the deficiency memo?
The 16th May 2023.
26th May.
Oh, sorry, 26th May 2023.
26th May, 30th May, 30th May, and 26th May.
ওইটা কোথায় আছে? Annex B is incomplete লেখা আছে, দেখো তো বার করো।
ওইটা এখানে আছে। Page 75.
My lord, kindly consider page 75, my lord. কোন জায়গাটা জানো?
এই তো। এই কোনো 75 ইয়েতে আছে।
Writ petition filed in August. In between, did he give any representation?
No, nothing. Nothing.
Individual assessee, sir.
He straightway come to
Is a proprietorship concern. What is all this? Poor fellow, sir.
My lord, kindly cease, my lord.
Wait. Sir, substantial amounts. First application is about 29 lakhs. Second is about 46.
Yes, amount is yes, substantial amount.
Supply and the proprietary, the fellow will die. Another is 36 lakhs.
Yes.
Yes.
This intra-court appeal by the revenue is directed against.
My lord, kindly shorten the time period for if they.
Is directed against order dated 3/10/2024 and WPA 19890 of 2024. The said writ petition was filed by the respondent herein for a direction upon the appellant/department to process the refund application and refund the amounts claimed therein in the light of section 54 of the CGST Act along with interest. The writ petition has been disposed of by directing the appellant to take appropriate steps and rectify the deficiencies pointed out by the department in the form GSTR RFD 03, and such application was directed to be processed within a time frame The department is aggrieved by the said direction and are on appeal before us. The appeal is time barred as there is a delay of 91 days in filing the appeal. When the appellant department alleges that the respondent assessee was not diligent in processing his application, they also should have been diligent in processing the appeal and should have filed the appeal within the period of limitation. So whatever applies to the assessee will equally apply to the department. Therefore, we would have been well justified in dismissing the application for continuation of delay. However, since we have elaborately heard Mr. Uday Shankar Bhattacharjee and a senior standing counsel, assisted by Mr. Tapan Baja, standing counsel for the department, we are persuaded to exercise discretion in the matter and condone the delay in filing the appeal. Accordingly, application in Can 1 of 2025 is allowed. Para. The undisputed facts are that the respondent writ petitioner filed 3 refund applications in the statutory format, namely GST RFD 01 for the period April 2020 to March 2021, April 2021 to March 2022, and April 2022 to March 2023. These applications were made on 19/5/2023, 20/5/2023, and 22/5/2023. The department uploaded a deficiency memo in GST RFD 03 on 26/5/2023, 30/5/2023, and 30/5/2023 by selecting the option inverted comma supporting documents attached are incomplete inverted comma close. It is true that immediately I think you would have made a representation.
My lord, kindly see page 75, my lord, along with the deficiency memo. There we have stated, my lord, the annexure B, declaration of and annexure B are not completed. Page 75.
According to the writ petitioner, the no details of the purported deficiency in the refund applications were uploaded in the common portal of the department. And in this regard, the screenshots of the common portal were filed to show that the deficiencies were not communicated. On account of this, the petitioner would, the writ petitioner would contend that they were unable to decipher as to on what grounds the refund application was returned as defective. After a reasonable period of time, the writ petition was filed. In the writ petition, the deficiencies on which the application the deficiencies based on which the application for refund could not be processed was submitted before the court, before the learned writ court, by the learned standing counsel for the department. And the statutory provisions were referred to, namely the second proviso to section 54 within bracket 3 and section 54 within bracket 3 within bracket 2i's of the Act, and rule 89 within bracket 5 of the CGST rules 2017, and rule 89 within bracket 2 within bracket H was also referred as, and it was pointed out that these are the deficiencies. In the portal, all that the assessee was informed is under the deficiency column, inverted comma, open. Supporting documents attached are incomplete, inverted comma, close. Therefore, it is an admitted. Therefore, it's therefore, it is not in dispute that the assessee was not made known of the defects which they are required to rectify. This is not only required for the purpose of compliance of the principles of natural justice, but it is a statutory mandate in terms of sub-rule 3 of Rule 9, where 9, which mandates that where any deficiency are noticed, the proper officer shall communicate the deficiencies to the applicant in Form GST RFD 03 through the common portal electronically, requiring him to file a fresh refund application after rectification of such deficiencies. If the deficiencies noticed are not communicated to the assessee, obviously they would not be in a position to rectify the deficiencies and file a fresh refund application after rectification. Therefore, the learned single bench was fully justified in permitting the writ petitioner to cure the deficiencies and submit the refund application which has been directed to be processed. As could be seen from the impugned order, the deficiencies are all not substantive in nature, but more procedural in nature. If that be so, the assessee should be given an opportunity to rectify the deficiencies. Therefore, we are of the view that the direction issued by the learned single bench was just and proper and calls for no interference. Since the statute mandates that a fresh refund application after rectification of deficiencies has to be filed, we slightly modify the direction issued by the learned single bench by directing the respondent writ petitioner to rectify all the deficiencies pointed out by the department, which was placed before the learned writ court and recorded in the impugned order, and upon such rectification and upon fully rectifying the defects, a fresh application shall be filed. Fresh applications for refund shall be uploaded by the respondent writ petitioner within a period of 2 weeks from the date of receipt of the server copy of this order. If the portal is unable to accept online filing, then the respondent writ petitioner is permitted to file a manual application which shall be processed in terms of the direction issued by the learned single bench. Dismissed with above direction, no cost.
My lord, kindly add one sentence. My lord, court below, my lord, couldn't take any, my lord, document at page 75A, where, my lord, the details has been given. What is the deficiency memo, my lord? But if I read, my lord, declaration and annexure B are not complete in nature. That has not been, my lord, considered by the trial court, my lord. And my lord, kindly record one is because this cannot be a precedent.
Make clear that this judgment and order shall not be treated as a precedent, but has been passed considering the peculiar facts and circumstances.
My lord, it is disposed of, my lord.
Dismissed.
Kindly.
How it will be disposed of?
My lord,
if we are affirming the order, it has to be dismissed
my lord,
with direction.
My lord, modifying the order.
That way, direction. Next. You please inform Mr. Jishnu Chaudhary, senior advocate.
I'll inform the advocate on record.
Advocate on record, whoever it is. Yes.
This is again, this is regarding Lordship, section 16(4). During the pendency of the writ petition, Lordship, there was an adjudication order passed, which we challenged before the writ court. The writ court, by passing the order, interim order, directed us to deposit 25 lakh before the Registrar General.
You should have withdrawn the writ petition and gone before the appellate authority.
Lordship, now at that time only finance bill was passed, wherein my entire demand was set aside on the ground that amendment in 16.5 was notified. But because it was Finance Bill and not Finance Act, so in the midterm, the learned Red Court ordered us to pay 25 lakhs. Now, Lordships, after the Finance Act came into picture, the matter came for extension of interim orders. Those orders we are carrying, Lordship. But that time, because state had not enacted their portion of the WBGST Act, so their learned Red Court again extended the order, the interim order, but subject to deposit of 25 lakhs. Now, Lordships, after repeated, because the direction of affidavit had been issued, and now the both CGST Act and WBGST Act had been amended, and the government come up with a notification dated 22nd October that I need to apply for a rectification in the portal. But the time period for that rectification was fixed as 6 months from the date of notification. That expired on 8th of April.
When the writ was pending.
And the writ was pending. Now, Lordship, I am not able to withdraw also. When we mentioned before the writ court, the learned writ court advised us that you withdraw, we will not give any liberty. So, Lordship, against all these backgrounds, I had no option but to file an intra-court appeal. Lordship, we kindly take this.
But you have complied with that 20.
Lordship, 25 lakh, it is with the Registrar General since July last year.
And you want that to be returned.
Lordship, it has to be that's.
Or you can give it to
Lordship, 4.5 crores was the demand. Entire demand will go under 16.5. Entire. Lordship, this notification.
In terms of this notification, you want liberty to file the
rectification. And the writ can be disposed of, Lordship. Because nothing will be paid.
So, if that rectification has to be filed, you have to be saved off on the limitation.
Lordship, because this particular says with a period of 6 months from the date of issuance of notification, para number 2 of this notification, it says so 8th of October, 6 months expired on 8th of April. Today, Lordships, if I file on the portal, I don't know whether portal will allow. So I can file a manual. In all the cases, Lordships, in fact, other high courts also in the same line have passed orders that when 16.5 has been brought in, this has to be, the orders has to be quashed and matter to be remanded to the lower authorities.
This is the central notification.
No, state also.
Both. State, where is the state? There is a state.
State notification has a page number.
State.
Now, this order doesn't permit them to file a rectification.
It goes back to the original. Lordship, that is why my prayer is today. What is happening?
No, we won't say any rectification.
No, Lordship. Lordship can remand the matter at the show cause stage, and when we can place this amendments before the authority, and authority is bound now.
But then what was the prayer in the writ petition?
There were twofold prayers, Lordship. One, we had challenged under notification issued under section 168A. 168A was, Lordship, extending time periods for department to adjudicate after COVID period. So those all are pending before the learned writ court, and the matter has reached the Supreme Court through Kerala High Court. So and there's an interim stay without any deposit in those cases. But because in this case 16.4 was covered, so learned writ court stated if you go for 168A, then we will not enter into 16.4. So Lordship, at that time we took the plea because 16.4 Finance Bill was already there. It is recorded in the learned writ court's order that Finance Bill has proposed this amendment. Kindly takes the writ court order.
No. First prayer is to declare
a notification.
168A is ultra vires.
That is pending.
Now what to do with that relief?
We are not enforcing that. We are not.
You don't press
we are not pressing it.
All right. Second is the order of adjudication.
Lordship, this is what we are pressing.
So adjudication order has to be set aside. Matter has to be restored to the show cause notice stage. And he has to take note of the
16.5
insertion of subsection 5 in section 15 and redo the matter.
Lordship, that is the.
And 25 lakhs will go to the.
Lordship, 25 lakhs, Lordship, so has to be because Lordship, in one of the matters, learned writ court had ordered 5 lakhs. That time, Lordship, the matter then when it came before Justice Honorable Justice Bhardwaj disposed of the matter with liberty to get that refund, and 3 months was given. Now, Lordship, 5 months have expired, passed away. We are still chasing with the registry for the refund.
You won't get it.
That is all, Lordship. Your Lordship.
What is the nature of business?
Lordship, distributors.
Distributing what?
Lordship, I'll just.
If it is diamonds.
No. Lordship.
You take the show cause notice. You will.
Lordship, business of supply of iron, steel, and textile fabrics. Page number 4, para 2.3. Lordship, actually, why the quantum? Lordship, they filed these 3 returns after the cutoff date. So therefore, the entire ITC which was taken in 3B was disallowed because of 16.4. That is why 4.5 crores demand. Otherwise, there is no other demand. The entire demand is covered under 16.4. And my predicament was this. And there's a delay, Lordships, because from July, I waited till September and then again there's a delay.
How many days delay?
Lordship, 297 if I take the first order, but if there are in between orders, but I cannot take in between orders because.
All right. This intra-court appeal by the writ petitioner is directed against the order. Where's the memo of appeal?
State notification.
So you have challenged only the 29th July.
Lordship, because in between interim orders, I cannot challenge. That is.
But the directed against the order, interim order dated 29/7/2024, passed in WPA 147/37 of 2024. By the said order, the learned single bench directed the appellant writ petitioner to deposit with the learned Registrar General a sum of rupees 25 lakhs within a period of 3 weeks from the date of the order, and the asset amount to be invested in any interest-bearing fixed deposit account with any nationalized bank, and the same should be kept renewed until further orders of the court.
That is what complied by this.
If the writ petitioner complies with this direction, there was a unconditional order restraining the department from taking coercive action against the writ petitioner.
This is the compliance one. It is recorded that
the appellant had complied with the said order, and the same was recorded by the learned single bench in its order dated 30th September 2024. The appellant is aggrieved not only by the condition imposed by the court, but also with regard to other subsequent developments which has necessitated the filing of this appeal. There is a delay in filing the appeal, and the delay has been sufficiently explained, and therefore the delay in filing the appeal is condoned and the application is allowed. On account of certain developments which had taken place during the pendency of the writ petition, both the writ petition as well as this appeal can be disposed of by this common judgment and order. In the writ petition, the appellant had primarily sought for two reliefs. First of which being seeking for a declaration to declare section 168 capital A of the CGST/WBST Act 2017 as ultra-virus. The second relief is to set aside the order of adjudication dated 22/1/2024. Mr. Ankit Kanodia, learned advocate appearing for the appellant, on instruction submit that the appellant writ petitioner does not press for the prayer to declare section 168A of the Act as ultra-virus. This submission is placed on record, and prayer A in the writ petition is struck off. This leaves us with only one prayer, namely the challenge to the adjudication order dated 22/1/2024. As mentioned above, certain subsequent events would be relevant to be taken into consideration for the purpose of deciding as to what relief the appellant writ petitioner would be entitled to. The Central Board of Indirect Taxes and Customs issued notification number 22/2024-Central Tax dated 8th October 2024, by which a special procedure for rectification of order to be followed by class of registered persons against whom any order under section 73 or 74 or 107 or section 108 of the Act has been issued confirming the demand for wrong availment of input tax credit, on account of contravention of provisions of subsection 4 of section 16 of the Act. The procedure has also been stipulated. Therefore, a window has been given to the assessee to rectify the defect, though certain timelines have been fixed in the said notification. More importantly, in terms of Section 118 of the Finance No. 2 Act 2024, correct?
Lordship, 118, yes. At page
Subsection 5 was inserted in section 16 of the CGST Act.
Page X1.
Which reads as follows. Sir, in this judgment, Delhi judgment, ASP, sir, it is here.
Should be pleased because
the above provision, above newly inserted provision, has come into force from the date of the notification, namely 27th September 2024. That is when the writ petition was pending before this court. Therefore, the matter has to be re-adjudicated by the adjudicating authority in the light of the insertion of subsection 5 to section 16. In fact, identical issues arose before the High Court of Delhi in the case of IC Electricals Company Private Limited versus Union of India, WPC number 1541 of 2024 dated 23/8/2024, wherein the court, after taking note of the insertion of subsection 5 to section 16, directed the adjudicating authority to re-adjudicate the show cause notice. This order was followed by the High Court of Delhi in ASP Microsys versus Union of India 2025-27 Syntax 394 within bracket DEL. Similar view was taken by the High Court of Jharkhand at Ranchi in Singh Construction Company versus State of Jharkhand 2024-23 Syntax 401 within bracket Jharkhand. The only factual difference in the case on hand is that the show cause notice has ripened into an order of adjudication, into an adjudication order. However, taking note of the fact that the statute has been amended by insertion of subsection 5 to section 16, we are of the view that the show cause notice should be re-adjudicated. For the above reasons, the appeal and the writ petition are allowed, and the order of adjudication is set aside, and the show cause notice is restored to the file of the adjudicating authority to be re-adjudicated, taking into consideration subsection 5 of section 16 of the Act, which has been made effective with effect from July 2017. Correct?
Retrospective.
First of July 2017. Sir, earlier I said the notification has come into effect from 27th September. No? Not here, the date is different. 1st of July 2017. The adjudicating authority shall afford one more opportunity to the appellant writ petitioner to submit a fresh, to submit an additional reply to the show cause notice and re-adjudicate the matter in accordance with law after affording an opportunity of personal hearing to the authorized representative of the appellant assessee. As mentioned above, the prayer to declare section 148A of the Act has been given up, and accordingly the said prayer has been struck off.
Lordship, 168.
168.
168.
168. Yeah. In the light of the above order, the amount of rupees 25 lakhs, which was deposited before the learned Registrar General, how much will the interest accrue?
Lordship, 6% generally.
No, how much will quantum?
Lordship, August, September, October, November, December, January, February, March, April, May, 9 months of 25 lakh, 10%. Around Lordship 2 lakhs. 2 lakhs.
That you give it to SLS.
And Lordship, one more thing which is troubling me is that my learned friend has assured me that the state of West Bengal has this mechanism, the 6 months mechanism. He has handed me a central notification.
No, that we are not going to that at all, because the problem will come whether we can extend the time.
Absolutely.
6 months from date of notification.
And Lordship has
when you adopted the notification, we don't know. When state of West Bengal adopted,
whether state of West Bengal has adopted or not, I don't have the
that is what you are saying. That is why we didn't go into that. We just mentioned that. 25 lakhs general and in turn directed to be invested in an interest bearing account shall be returned to the appellant. The commission also will be deducted.
Lordship, they deduct the commission.
After deducting the commission, deductible. So far as the interest which has accrued on the said sum of rupees 25 lakhs, the same shall not be returned to the appellant, but credited to the account of the West Bengal State Legal Services Authority. Thank you.
Lordship, some time may be given for the refund.
The above direction be complied with by the registry within by 27th June.
Grateful.
Because vacations are there.
Much okay. Grateful.
Start directly. 25 will be returned after deduction. Registrar General, remit the amount.
Yes, sir.
Whatever interest has accrued. Allowed with direction. Next.
Number 10. The next I appear for the petition. It's the mercy petition, Lordships. My adjudication order was.
We are for the Union of India, man.
My adjudication order was passed. I could not participate because the person who was looking after was suffering for cancer. We have attached Apollo Hospital documents during that period. Our only prayer before the learned writ court was that one opportunity may be given to us because the issue relates to retrospective cancellation of suppliers registration, and my ITC has been denied only on that ground, Lordships. Unless I produce all the papers, my bank payments, my challans, road transport details, which I have, I am not able to get an opportunity in Lordship. In the order, they have referred that 2 opportunities were given. But Lordship, because that person was suffering from cancer and those documents were also attached, we are just as a mercy petition for one opportunity within fixed period. Within 7 days, 10 days, we will appear and we will submit our documents. Then whatever adjudication order is passed, Lordships, will comply with the same. We will go to appeal. But the learned writ court order us to go to appeal.
My lord, kindly come to page 153, my lord. July 2024, my lord, we have issued the show cause notice for irregular availment of ITC. Now, my lord, we have given, my lord, personal hearing, if your lordship kindly see. Through email as well as by post, we have given the personal letter of personal hearing on 8/10/2024, 1/11/2024, and 2nd December 2004. He has not filed any reply, nothing. He has not responded to this. Now, order in original has been passed and directing me to disallowing the ITC of ₹5 crores and also interest, the penal interest. Now, this is an appealable order. Learned trial court has, writ court has directed to avail the alternative remedy, my lord.
Lordship, may kindly take page 132. It was my only prayer was because the person, it was a JV company. When it's a joint venture, Lordship, two companies, well, one accountant is looking after the files, Lordship. And that person himself was suffering for the ailment, and that is the only reason. Lordship, a small window of 7 days also would suffice for us, because the issue is only for RC cancellation of my suppliers. I have all my bank account payments and everything, Lordships. One opportunity if can be given, Lordships, this company, this, because it's a joint venture, Lordships. A joint venture for transport.
My lord, the period the admission before the, my lord, if your lordship kindly see page 132, the period is 30th April 2024 to 6th May 2024, and the personal hearing has been given after March, more than five months later. He has not participated, he has not done anything, and now this is irregular availment of ITC, my lord. At the cost of the government exchequer, they are enjoying the money, they are not giving to the government, my lord. They are not paying.
They are doing business with government money.
Government money. Yes.
They've invoked section 74.
That is better way of putting it.
Yes, they've invoked section 74 suppression. Everything is there, Lordship. Yes. The only issue is of cancellation of RC of my suppliers. I will, Lordship, if one opportunity is given me to produce documents, whatever the order comes, I will have to abide by that time, whether to appeal or whether I will need to file appeal or whether I can get one chance, Lordship. It is a mercy petition, Lordship. I am not anything more.
Chance has been given, my lord. He has not availed this. Now, he is the appellate remedy, my lord. Appellate remedy.
They have invoked 74, Lordship, suppression. They say your RC cancelled suppliers, therefore you have suppressed. All these points, Lordship, if I cannot litigate before the adjudicating authority, Lordship may put me to some terms. But Lordship may grant me one opportunity to appear before the...
Because it is not as if on a single day something has happened.
Yes.
And proceedings were there,
Lordship,
statements were recorded, Panchanama was
Lordship, that is
alert circulars,
Lordship,
everything is there.
That is what we want to give as reply, Lordship, because those things it's of my suppliers.
Therefore, it is not that the JV was not in the know of things. Probably you are right. One person must have been handling it, but the company knows about it.
Yes, company knows about it. Lordship, the person who has affirmed this also, this person himself came, who was suffering from cancer. He himself came, and that is a fact on record, Lordship. As an officer of the court, I will not say something which is...
We are not saying that.
Lordship, so that is why it's a mercy petition.
My lord, April 24,
one opportunity, Lordship.
April 24, he was released from the hospital. Now, my lord, these so-called issues, my lord, kindly says 18 July 2024. There is no ground even, my lord.
What did the learned single bench do?
Learned single bench says you would need to, there's an alternate remedy.
Yes, certainly.
We have to send it to the adjudicating authority. The condition will be more severe than the appellate authority's condition.
Kindly, Lordship,
if you go before him, 10% only, you deposit it. But here it will be 50%.
Lordship, because of the health condition of the person who has affirmed the petition himself,
we will give you, but you pay up 50%. It is better you go to the appellate authority.
In all these cases, Lordship,
we will say that he will be permitted to raise all contention.
All condition, Lordship, Lordship knows that appellate authority cannot improve. Today, appellate authority, whatever I give my documents,
we will ask him to do the exercise as to be done by the original authority.
Lordship, appellate authorities never going beyond the whatever is the statute, Lordship. And Lordship, on that fact, Lordship, they have invoked suppression and everything. One chance, if I can prove that, how can 74 come into picture at all in my case? Because
therefore, it is only on facts. 10% you pay and go.
Lordship, it's a JV company. Otherwise, I would have not come into appeal before.
JV company means who's the other JV partner?
There are two
from Singapore.
No, Lordship, there are two companies, Indian companies into a JV. Lordship, one opportunity, Lordship, I have attached certain judgments on mercy, Lordship, that mercy petition can be taken. Lordship,
I will fake invoices. There cannot be mercy in this matter.
Lordship, I kindly take page 162. Lordship,
there is no case even made out in the writ petition for connoting his not participating in the reply. He knows everything.
Lordship, this is something going beyond, Lordship. I am on
one person who released from the hospital in April 24, so-called issues in July 7, 24. What he has did, why he has done.
Lordship, I am only on
that is the partnership farm has been closed, my lord.
See, the appellate authority shall treat the appeal petition as a first statement of defense.
First statement, Lordship,
we will improve upon that.
Lordship, that cannot happen, Lordship. Practically in appeal, it is next to impossible. Lordship might put me to some terms.
Mr. Kanodia, then there will be no end to it.
Lordship, may put me to some terms.
They will produce, we will say not to be treated as precedent. In another case, they will produce this order.
No, Lordship,
They'll take it to the single bench
Lordship,
and
may,
say, see what you-
Lordship may put me to terms. I'm on instructions saying, Lordship may put me to terms for some impose some cost because of this person, Lordship. It has happened. We will one opportunity. Lordship, let me please.
No, you don't
There is no
blame the
case.
person.
Lordship, that is why I'm saying because
already he is suffering.
Lordship, that is why I'm saying that for one particular SSC, Lordship, one opportunity may be given so that I can place 7 days time may be given, Lordship. Within 7 days, I will place all the documents, whatever order is passed, Lordship. May put to me some terms, Lordship. Kindly appreciate, Lordship.
Well, had that been a case,
Lordship, it's a case of 74. It is not that it is becoming time barred. It is not a case of time barred also. 74 separation.
But you filed, when did you file the writ petition?
Lordship, we filed the writ petition
In March.
in March itself.
And the order was passed in December.
Lordship, December they served, it is uploaded in January only in the portal.
Well, everything they are watching, just to watch and come
Lordship, within 1 month,
marching of the court.
We have heard so and so.
Within 1 month is what I
This
can.
intra-court
Lord,
appeal,
kindly condone.
this intra-court appeal has been filed by the writ petitioner challenging the order dated 5/5/2025 in WPA 3032 of 2025. In the said writ petition, the appellant had challenged an adjudication order passed under section 74 of the WBGST/CGST Act 2017 dated 8 January 2025. Since the order is an appealable order, the learned single bench has relegated the appellant to avail the appellate remedy. After elaborately hearing Mr. Kanodia and Mr. Uday Shankar Bhattacharjee and a senior static counsel assisted by Mr. Tapan Banja static counsel, we are of the view that the learned single bench was fully justified in relegating the appellant to the avail the appellate remedy. It may be true that the person in charge of the taxation matters of the appellant, which is a joint venture company, was suffering from terminal illness. But going by the facts, it is seen that there has been a inspection which was conducted, Panchanama has been recorded, statements have been recorded, and the matter has been in progress for quite some time. Therefore, all factual issues needs to be placed before the appellate authority so that the appellate authority can examine the matter. The interest of the appellant has been sufficiently protected and safeguarded by the learned single bench by observation in paragraph 8 of the impugned order, wherein the appellate authority was directed to treat the appeal petition as a first statement of defense of the writ petitioners and shall also provide an opportunity of hearing to the petitioners and decide the appeal on merits and in accordance with law, subject to the appellant complying with the other formalities like pre-deposit. It goes without saying that the powers of the appellate authority are coterminous with that of the original authority. The appellate authority will be entitled to reappreciate the factual position, accept documents, and if need be, also call for remand report from the lower authorities and take a decision in the matter. The entire adjudicating authority's file can be called for and examined for the correctness of the decision-making process as well as the decision itself. Therefore, the powers of the appellate authority are wide enough to take note of all contentions that may be advanced by the appellant in the appeal petition. Therefore, we find no grounds to interfere with the impugned order. Accordingly, the appeal is dismissed. The appellant is directed to file the appeal within a period of 15 days from the date of receipt of the server copy of this order. And if the pre-deposit condition is complied with, the appeal petition shall be entertained without reference to limitation, and the appeal be disposed of on merits and in accordance with law after affording an opportunity of personal hearing to the authorized representative of the appellant. Thank you.
Number 11.
Lordship, in this matter, Mr. Tonoy Chakraborty is there. I am not there in this matter.
I'm appearing on behalf of the writ
Lordship,
petitioner.
he is arguing a matter before in some other court. Your Lordship, kindly take
We'll
up
say after vacation. You wanted to say. Only
Your
two
Lordship.
more.
Our appeal, I tell your lordship took up this matter day before yesterday. I was absent. Your lordship was taking it virtually. I was absent, so I will not
problem.
oppose to
No,
that.
the
But your lordship kindly takes it up tomorrow if it is.
We will say not today.
Lordship, after vacation, if your lordship takes up after vacation.
Well-
Suffering, your lordship, I've been given an order of favored with an order of regularization, but nothing has been done. The contempt is pending. I've prayed for an adjournment there since the matter appeal is pending.
And what was he working as?
As bus drivers on contractual basis.
They will not do it, sir. You take it from me. We will dismiss their appeal also. They will not comply. They will take it to Supreme Court. SLP will dismiss. They will not comply. You won't believe it. Myself and Justice Bivas Patnaik are hearing a matter. When we started hearing, when we were in court 16, that's 4 years back, when I was transferred back here, we affirmed an award of the Industrial Tribunal. It relates to the drivers and conductors of the North Bengal State Road Corporation. Yesterday, the contempt application we have taken up. What they did after all this, they appointed them as fresh incumbents, fresh employees, as watchmen, etc. Probation for 1 year. We had to quash that condition and convince the petitioners. They will not. You know how many contractual staff are here in the High Court?
No, I understand.
Huh?
What has fallen from your
No,
lordship?
you need to know, sir, as an officer of the court,
Yes.
you need to know that we are not in a bed of roses. How many Group D are there? How many Badali workers are there? You know what is the salary of a Badali worker who's bringing your files here? Case files who's coming in, what is his salary? He starts with 13,000 rupees. And the maximum he reaches is 28,000 or 26,000 after 24 years of service. A contractual staff enters service with a monthly on a daily wage payment of about 259 rupees or 239 rupees per day. And salary is calculated and paid for 26 days, but they are working for 31 days or 30 days. In Jalpaiguri Circuit Bench, there are 33 staff members who all came to me this time. They have been working for 6 years now. 6 years. And they are being paid 239 rupees per day for 26 days, but they have to be for 31 days or 30 days. They will not do it, sir. Please take from me. I am going to go away from here very soon. They will not do it. You know, you you get into any tram, 1 or 2 trams are running, you get into those trams. The fellows, there is another fellow who's working in the Chief Justice residence. He sweeps 7 days a week, rain or shine, he sweeps. What is his salary? 6,000 per month. Where are we heading to? Let your good friend or Tanay Chakraborty, let him convey to the Advocate General also. You will only get a paper order for your client. You mark my words. In fact, we had to threaten, call the chairman of the North Bengal because he is he's not an executive officer. He's not managing director. He's an executive. Chairman is a political person. So we said we will issue a notice of contempt and bring him here, and the police will escort. Then they did half complaint. Up to yesterday, sir, it has not done. In fact, I have dealt with contempt in my parent High Court. We have dealt it for 6 years. McNichol and Magar. The company went into liquidation. One of the factories is here, one is there. Every week the matter will come up. I was the junior judge, then I became the senior judge in the division bench. Every 2 weeks, 3 weeks, one employee will die. Ultimately, what relief they got? We attached one property. That attachment order was upheld by Supreme Court. Therefore, money came. By then, the person who was leading the team was 89 years old. His life, he sacrificed for his co-workers. They will not do it, sir. There's no point.
In a similar matter, something similar has happened. There was a regularization of bus drivers on the basis of which this writ petition was also disposed of. There was a contempt.
He will dismiss it with cost also. Today or next week we will dismiss it, but they have to, in my little experience of 4 years here, they will not.
That is a practical thing.
Very
Only
sorry
thing-
state. See, every time you look at this employee, it pains. 6,000 rupees, what can a person do, sir?
In today's time.
And they what when we put it to, I put it to the highest authority of the state. The response is there are more than 2.5 lakh employees throughout the state like this. The state runs on temporary workers, temporary staff with no commitment at all. You remember the textbook theft case?
Lordship, I was not.
You don't remember? Mr. Siddiqui appeared. The textbooks which were supposed to be supplied to all the government schools, all the schools, was kept in a godown. About 18 lakhs or 19 lakh books. Everything was stolen. After 1.5 years of investigation, they registered an FIR against 2 of the watchmen of the godown. Both of them are contractual. Do you mean to say this fellow 19 lakh books he carried on his head?
Lordship knows better than me, Your Lordship.
That is a big racket. Then the state government filed a compliance report saying that we have supplied new books, all children are happy. What happened to the stolen books? Suppose 15 books is missing or this pen and paper I can put and take it off. 19 lakh books, whether he'll carry it in his head. That's how it operates, this machinery. And if the prosecution is supporting this, what else? Where will you go? We'll fix it on 11th June. Huh?
Only thing a
But
similar
don't give
matters-
any
No,
hopes to your client. Huh?
I understand completely what has fallen.
This
from
is
your
my
lordship.
personal advice, not
I bow
sitting
down,
here on the
I
division
bow
bench.
down, Your
You won't get it.
Only thing is that another writ petition was disposed of in a similar matter, and they have
We'll do it.
also filed.
In fact, I was telling about North Bengal Transport. They have given them fresh appointment. The minimum scale starts at 14,500, maximum is 16,200.
In this matter also, there was a contempt and similar consolidated remuneration. They say they term it as regularization, but they are giving a consolidated remuneration. Against
How much they gave here?
16,000. That was the starting amount, and after 10 years, it was increased. That was that was before Justice Mantha. Lordship, only thing is that another
They will do
appeal is-
all
both the
gimmicks.
appeals may be
They'll do
taken.
all gimmicks. What they'll do is your friend will advise file SLP there. Then diary number. They'll take adjournment contempt. Then he will say one petition can to recall and modify the order. We dismiss it, not maintain it.
Better people.
Then we file review.
Lordship, they have better people to advise.
Review. Keep the review in the department itself. Wait and see what SLP is. SLP Supreme Court is about dismiss. My lord, we'll move the High Court. We'll withdraw the SLP. Liberty may be granted. Dismiss. Liberty granted without expressing any opinion. They show the order to the High Court here. We have filed review. You take up the review. We dismiss the review. Against the review, they go up. Cost of litigation, if they pay the poor workman, he'll be saved. They won't do it. Yeah, the other matter also, they took it on appeal twice against one interim order passed by me and Justice Bivas Patnaik and the final judgment authored by Justice Patnaik. 2 SLPs. Imagine one SLP, how much it would have costed them? At times, I feel very sorry for these people.
The prayer before your lordship is
Yes,
that
yes, it
both
will
the
come in the
appeals may
same
be-
caption. List the learned advocate appearing for the appellant. The respondent submits that the appeal may be heard and disposed of at the earliest, as the writ petitioners are suffering, despite an order passed in their favor, which was passed following another coordinate bench order, which was implemented.
Not implemented, your lordship. That was there subsequently, since it was an order of regularization, and they said that there was a consolidated amount. The officials were called, and there was
will
an
not
order
say that, huh?
against that SLP is there. I am not
It is
taking your
submitted
lordship.
that Mr. Tanoy Chakravarti and a government council appears for the
That appeal may be tagged.
appellant.
The appeals may be taken up together.
And adjournment is sought for on his behalf. Let the matter appear on 11th June under the same caption, higher on board.
And that other, if your lordship kindly text the other appeal as well.
List a matter so and so along with this.
I'm giving the number. Great.
Lord, before your lordship rises, my lord, may I mention one matter, my lord? My lord,
10:30 only mentioning.
my lord,
Number 15, let it be after
Upgraded. After vacation.
my
15.
lord, there is some urgency, my lord. My lord, yesterday, my lord had heard a matter, my lord, regarding, my lord, the 17-18 tariff year of electricity, my lord, where there has been illegal disconnection of electricity of one factory, my lord. My lord, in that matter, my lord had passed a direction that from today, 3 p.m., my lord, electricity was to be reconnected, my lord. My lord, in the order, my lord, I believe, my lord, inadvertently, the date has been recorded as 25th of May, my lord.
No, that we have corrected.
My lord, page 10, my lord, of the order, my lord.
No. We said 3 p.m. tomorrow. That is today.
Yes, my lord. My lord, the order record.
That was the understanding.
My lord, the order. My lord, seventh line from the top, my lord, if my lord kindly sees.
Which page?
My lord, page 10, my lord. Page 10 of the order.
7th line?
From the top, my lord.
Oh, 3 p.m. 25. You show us in days list. But how they won't be able to comply it today?
My lord, they have reconnected the electricity, my lord, but if there is some kind of disconnection, my lord, again because of
the matter has been mentioned. No, upon mentioning the matter is treated in the day, what is it? Days list under the caption to be mentioned. It is submitted that in the order dated 25/2025 in MAT 395 of 2023, etc., there is a typographical error in page 10, which is the continuation of paragraph 4. The order, the order that was passed was to direct restoration of supply of electricity to the petitioner in the CAN application by 3 p.m. on 21/5/2025. However, the date has gone down wrongly as 25/5/2025. This mistake shall be rectified and the date shall be corrected as 21/5/2025 instead of 25/5/2025, and this order shall form part of the order dated 25/2025. The learned advocate for the petitioner submits that the electricity supply has been restored. This submission is placed on record.
Yes, my lord. Most grateful, my lord. Most grateful.
Lordship, I had mentioned the matter today after recess, and you were pleased to grant me leave to move with the matter before vacation bench. Kindly, Lordship, I am praying for 3rd June because Council Mr. Banerjee says to go on eye operation. He will be incapacitated in
3rd June.
3rd June, Lordship.
The very
But
next.
you please inform the other side.
Yes, I am sending them email today.
The very next matter, my lord, this matter is regarding immediate absorption basis of the person, my lord, he was in the Navy. Then, my lord, regarding that issue, my lord,
where you want to get absorbed?
No, my lord, I have been re-employed, my lord, not immediately absorbed. So, my lord, my pay protection has not been granted.
My lord, heard the matter.
On of the occasion.
Let it remain in the
But the only difficulty is that he is going to retire on 31st of May. So, if tomorrow, if the matter can be taken up,
Mr. Victor, that's not possible, sir. If possible, we will do. Tomorrow, there may be some inconvenience for me also. I don't know. How is the list tomorrow? This will come tomorrow? This will come tomorrow. Let us see tomorrow. Very difficult. You are not going out anywhere.
My lord?
For vacation.
Vacation?
All work and no relaxation makes Jack a dull boy. So therefore, you need to take a break. That is why this vacation is given. We have 4 vacation courts. In fact, ladyship is also going to sit.